My lord,
Any mentioning?
my lord, I'm to mention your lordship's appellate matter, your lordship, regarding the contempt, your lordship. Lordship, I'm for inclusion in the list. I'm mentioning for inclusion in the list, your lordship. Contempt matter, your lordship, lordship passed order in the 4th of 2024.
Where is the order?
My lord,
Order
may I throw my tab, your lordship, to leave with that. Peaceful. Grateful, my lord. No.
Item number 1.
Lord, it's my application for restoration of my writ petition, which was dismissed for default on 23rd of November 2023. Lord, Lordship will find the order of dismissal at page 135 of the application. Lord, instead of troubling your Lordship, Lord, I'll just cut the matter very short. Lord, the only objection taken by my learned friend in the affidavit in opposition is, my Lord, that the restoration application is not accompanied with a separate application for condonation of delay under Section 5 of the Limitation Act. But may I respond to that? My Lord, this is a writ petition. This is not a suit. Had it been a suit, my Lord, Article 122 of the Limitation Act would have been applicable. But writ petition, my Lord, will be governed by the residuary article, that is Article 137 of the Limitation Act, which provides for 3 years. Now, my Lord, if it is 3 years, then, my Lord, from 23rd of November 2023 till date, I am within the timelines to file the application for restoration. My Lord, I am led by Mr. Ghosh Lakshman.
May I file the affidavit in reply first? But as my learned junior has already submitted, there are two principal grounds of objection by the respondent to this restoration application. One, he says there is no separate Section 5 for condonation of delay. And second, he says an entity which ought to have been made a party in the original writ petition is not made a party. Your Lordship will scan the affidavit in vain to find any other ground. So, as far as the first ground, and which is really the only ground according to us, that is a point of limitation. First and foremost, I say that in a writ proceedings, there is no question of limitation. Limitation Act does not apply to writs. That is settled. That is settled. My Lord, even if I come 3 years later to file a writ after the incident has happened, no question of Limitation Act applying, but the court will also sometimes, because it's a question of fundamental right being violated, there cannot be any limitation to that. Be that as it may, even if we assume that, and I'm going to cite a decision to that in writ proceedings, question of applicability of Limitation Act only is questionable, and in fact, it is not applicable. That's the first point I'm making. Second, assuming it is applicable, then also, my lord, as my learned junior rightly says, the period of limitation for recalling of an ex parte decree under Article 122, your lordship knows, is 30 days. But since there is no specific article for recalling of a order passed ex parte in a proceeding like a writ, my lord, the residuary article of Limitation Act, Article 137, will apply, which says 3 years from the date of the event happening. Now, here is a case, my lord, where the the dismissal happened within 1 year of our making the application. So question of limitation, even if assuming Limitation Act applies. And the last point which my learned friend has taken, that an entity had to be added as a party, but first the writ petition has to be restored. In a restoration application, I cannot change the cause title and file a restoration application adding or subtracting any party. If your lordships are with us and your lordships will not restore the matter, then my lord, of course, my learned friend can take a point that some parties are not added and your lordship will decide. But as far as the point of limitation is concerned, but first kindly, my lord, take the Limitation Act itself. Kindly takes 122 first.
Limitation like
And I can also hand up a copy, my lord.
ওনার কাছে আছে ছেড়ে দাও। এটা তো
But first is Article 122.
application.
Kindly see, to restore a suit or appeal or application for review or revision dismissed for default of appearance or for want of prosecution or for failure to pay costs 30 days from the date of dismissal. So to restore a suit or appeal or application. This is not the case. This is not a suit. Kindly come to now Article 137.
Yes. ওনার সুবিধা হবে, ঠিক তো? Mr. Ghosh, you take this book. I have one.
Oh. But kindly takes, my lord, Article 137, which is the residuary article, my lord,
Yes.
which, my lord, clearly says, my lord, any other application for which no period of limitation is provided elsewhere in this division, 3 years from when the right to apply, Article 137. So according to my humble submission, no period of limitation is mentioned in any other article for recalling of an order past ex parte. 122 is only for a decree past ex parte. Order past ex parte, that too in a 227, there is no specific article. Now, my lord, I am saying 137 will apply, and not only me, I am supported by very high authorities on this point. My lord, kindly, my lord, first take, my lord, the but kindly takes, my lord, 2005 2 CHN 642. 2005 2 CHN 642. This is also, my lord, a writ petition. Your lordship will see the first paragraph itself. The respondent number 1 before us filed a writ petition being WP number such and such, which was initially taken up on such and such when certain directions were given. Thereafter, directions were also given for filing of affidavits. Paragraph 2, the writ petition appeared after an interval of almost 4 years in the warning list. The learned single judge on such and such as well on such and such. And the same does not appear to have been called on for hearing. On 15th March 2004, when the matter was ultimately taken up, no one appeared on behalf of the appellant bank and the hearing of the writ petition was adjourned till such and such. The direction of the advocate on record to inform the such and such. Then 3, as will appear from the affidavit of such and such, respondent bank did not accept the notice on the ground he had no further instruction. Learned advocate requested the writ petitioner to serve bank. On the same day, that is 15th of March 2004, paragraph 3, a notice was sent to the learned advocate on record. However, on 17th March, still no one appeared on behalf of the appellant bank, and the hearing of the writ petition was concluded by the learned single judge who reserved judgment and ultimately delivered judgment on such and such, allowing the writ petition with certain directions to the appellant bank. Our case is much better. It was only dismissed for default. Now, my lord, kindly, my lord, come to paragraph 6. The application for condoning the delay in filing the application for recalling the judgment and order dated 26 March 2004 passed in the writ petition was taken up for hearing on 15th October 2004. After considering various submissions made on behalf of the respective parties, the learned single judge was not satisfied with the explanation given for condonation of delay and accordingly dismissed the said application. Consequence such dismissal, the application for recalling and modification of the order also suits. So, my lord, the honorable judge, my lord, dismissed the section 5. As against the said order of the learned single judge, these two separate appeals have been filed. Now, paragraph 8 onwards is the, my lord, real proposition. When the application regarding prayer made for recalling of the judgment and order in the writ application was taken up for consideration, a query was put to the learned counsel to the period of limitation which would be applicable in making such an application. In answer to our query, Mr. Bimal Chatterjee, learned advocate appearing before the appellant bank, submitted that although arguments had been advanced before the learned single judge on the supposition that Article 122 of the Limitation Act would have been applicable to such application, upon, my lord, I am laying stress on this, upon further examination, it would appear that Article 122 would have no application to the facts of the case. A writ petition was involved, particularly when the application was one for recalling of an order and not an application either for review or revision. Mr. Chatterjee also argued that it could be urged that Article 123 may have application. Strictly speaking, the same would also not be applicable to the instant case, as has been defined in 2.2 of the Code of Civil Procedure to mean the formal expression of adjudication. Now, my lord, paragraph 9, on the other hand, it was submitted by them that it is in fact Article 137 of the Limitation Act, which deals with applications in general. Oh, no. I'm sorry, my lord.
Yes.
Which deals with applications in general for which no other provision has been made which would apply to the facts of the case. And in such an event, the period of limitation would not be 30 days, but 3 years from the date of the order. Mr. Chatterjee submitted that since the judgment had been delivered on 26 March 2004, and the application for recalling the order had been made on 6 July 2004, such application was well within the period of limitation as prescribed under Article 1. This is exactly what I am also arguing. But I am not troubling your lordship with the kindly, well, kindly now comes to the finding of the honorable judges. Paragraph 18.
Yes.
On a careful consideration of the submissions made on behalf of the respective parties, it is quite clear that Rule 53 of the Rules of the High Court under Article 226 of the Constitution makes the Civil Procedure Code wherever possible applicable to proceedings under 226. But the same does not ipso facto bring within its ambit the law of limitation with regard to suits. Both Articles 122 and 123 of the Limitation Act clearly refer to suits, whereas Article 137, which is the residuary provision, deals with applications of all kinds for which no specific provision has been made. Apart from the above, Rule 53 of the writ rules, which indicating that the provisions of the Code of Civil Procedure in regard to suits shall be followed as far as it can be made practicable in all proceedings under 226, also indicates that the rules shall not be deemed to limit or otherwise affect the inherent power of the court to make such orders. 19. In our view, the said expression recognizes the inherent power of the High Court to deal with matters applicable to proceedings under 226. We are of the view that Article 137, which deals with applications of all kinds, would have application in these matters. It may be pertinent to reproduce the language of Article 137. I have already read before your lordship. 20. The aforesaid view is bolstered by the observations made by Honorable Supreme Court in the case of Kerala SC Board Supra, in which it was clearly explained that Article 137 and 1963 Act is applicable to any petition or application filed by any act to a civil court. Undoubtedly, the writ court primary functions as civil court dealing with civil matters. In such circumstances, we are inclined to allow both the appeals and the applications for stay are all treated on the days list. So, my lord, the applications for condonation of delay has been allowed. The appeals have succeeded, and the division bench of this honorable court is of the view that Article 137 is the article which applies. In fact, first it says no, my lord, Limitation Act can apply, but even assuming it does, well, it is Article 137 and not Article 122. If that is the case, my lord, it's a 3-year period. I have come within 1 year. I am saying there is no question of application of Section 5 in this matter. My lord, I am further bolstered in this matter by my lord, as I was saying, my lord, as a further, my lord, corollary to my argument, that in fact Supreme Court has said that Limitation Act does not apply. There is also a whisper in this matter, my lord. Kindly sees 2000. This is 2013 SCC Online Calcutta 7828. একটা copy দিয়ে দিচ্ছি। Kindly come to page 2. আছে? Now kindly takes the second page. Second paragraph, my lord, third paragraph. The power of the High Court vested in it under Article 226 of the Constitution cannot be abrogated or limited by any statute. The constitutional power which has been vested in this court stands on a different footing than power vested in any court trying civil or criminal matters. The Limitation Act is in no way applicable to matters invoking the writ jurisdiction of this court. In fact, Section 141 of the Code of Civil Procedure explains that the expression proceedings includes proceedings under Order 9 but does not include any proceedings under 226 of the Constitution. What more do I show? Limitation Act is not applicable. The division bench says even if it's applicable, it would be, my lord, Article 137.
Yes.
These are the two judgments I'm relying on. Now, my lord, kindly comes to the facts of this case, my lord. Kindly come to page 135, my lord. Order of dismissal. It is not also, my lord, a reasoned order as your lordship had found in the division bench. This is just a simpliciter order of dismissal. No, my lord, merits gone into. Page 135, none appears on behalf of the petitioner and no accommodation is sought for. In view thereof, the writ petition stands dismissed. This is, my lord, 23rd of November 2023. My lord, kindly takes the application that has been made before your lordship. That is, my lord, affirmed on, my lord, 4th of November 2024. My lord, say, give or take, my lord, a year later. Now, my lord, kindly come to the grounds, my lord, we have taken. Even then, we have tried to explain why, my lord, we have come a year later. My lord, kindly takes, my lord, paragraph 70 on. Yes, day-to-day analysis, my lord, as if, my lord, Limitation Act applies, my lord, we have tried to explain from paragraph 17 onwards to 31. I'm not troubling your lordship by reading it. My lord, day to day, or my lord, how we have come to know, when is the first time we have come to know, what are the steps we have taken, what are the due diligence undertaken, how the draft has been made ready, every other detail, my lord, has been given. There's a change of advocate. Paragraph 19, there's a change of advocate because, my lord, we lost trust and faith in the previous advocate, my lord. Then, my lord, the new advocate assumed the entire, my lord, charge. The main person of the client, my lord, who was looking after the litigation died. We have given all these particulars. We have given
Who is this?
specific names of the advocates to whom, my lord, the petitioner's advocate, the advocate on record had taken the petitioners for, my lord, drafting the petitions. Conferences held. Each and every particular has been tried to be furnished by the petitioner. We have not taken it lightly. My lord, paragraph 28, your lordship sees. Mr. Sonthalia was the person. 28, 29.
Okay.
So Sarogi was the person who was, my lord, looking after the matter, my lord. The person who was looking after, he, my lord, died. That averment is there at paragraph 17, my lord, page 11. And, my lord, this
Who is
person who
Mr.
was,
Kiran Santhalia?
that person is the constituted attorney, my lord, who is now dealing with the matter. Paragraph 28 and
Previously,
29.
Mr. Sarogi used to look after the matter.
Yes, he, my lord, died. That is why there was a gap. And now, my lord, Mr. Sonthalia, who is also aged, 72 years, and is suffering from ailments, my lord, is taking the cajoles of the, my lord, of my lord, proceeding with the matter. But, my lord, even because of his health, my lord, some stultified progress had taken place because there was a lot of back and forth between the clients and, my lord, the advocates. In any event, my lord, it is only a year that has lapsed since the dismissal. I am saying there is no question of limitation. But yet, since we are before your lordship and it is a discretionary order after all, your lordship has to be satisfied, lordship conscience has to be satisfied. We have taken steps immediately after coming to know. We have given day-to-day, my lord, analysis as to what has been done. But kindly takes the affidavit in opposition, my lord. The only 2 points my lord, have already submitted is my lord, the point of limitation, page 3, paragraph Roman I, 3 Roman I. That a separate section 5 application had to be made. Three I and 3 Roman 6 at page my lord, 3 and 5. They have taken this point of limitation and no separate application being filed. It's really, my lord, limitation, limitation, and limitation. And my lord, finally, my lord, they also say that, my lord, one entity had to be added, my lord. That point is there, my lord, at my lord, page, my lord.
Which paragraph?
No, my lord, that I believe my learned friend had submitted orally, as my learned
Oh.
junior rightly points out. That may not be in the affidavit in opposition per se, but my lord, to answer that, my lord, definitely, my lord, that stage will only come at the writ petition stage, only if your lordship is kind enough to restore. Well, these are the facts, my lord. Let my learned friend answer.
Next day, no? I have some.
Again, our application.
There's
Application on
nothing
next
to
day, make your
answer.
submission.
After date, my lord, if my lord 3 years, it is, my lord, I support this. If he, my lord, if his application allowed, my lord, then it is very, it is the petitioners. Everybody will come, that is 3 years. No, application for section 5. My lord, I must see the prohibition of the, and I must come after sometimes. My lord, it is our petitioners. I am not in the against the petitioner. My lord. If that is established, my lord, then my lord, petitioner will not file application, separate application of section 5, my lord. So, my lord, I must see that. It's another date, my lord, and as I have some. To my lord.
Application. Affidavit in reply filed on behalf of petition is taken on record. It is reply on behalf of the petition is taken on record. But Mr. Rupa Ghosh, learned advocate for the petitioner. Applicant goes. Applicant petitioner. Concludes his argument. So Chondicharan Day, learned additional government leader. Some accommodation. Monday.
If it
Monday,
can
Tuesday,
be
Monday,
yes, on Monday or Tuesday, it is absolutely fresh.
My lord, your lordship, next on 20th.
I'm,
20th, I'm not there.
I'm beseeching my learned friend to do
20th,
it
I will
freshly.
not be here.
Admit that.
On Monday or Tuesday, whatever you choose.
My lord, Monday and Tuesday, my lord, I am not in Calcutta, only for that reason.
Wednesday then. Application will get on Wednesday.
মাত্র ওই মামলাগুলো কোথাও ওয়েডনেসডে আছে না শুক্রবার আছে
Wednesday, my lord.
then my lord, your lordship is Friday another
No, that is separate, my lord. Wednesday, my lord, we'll come back.
Item number 2,
Worship, I am for the petitioner here. Kindly make it not to take that earlier days the direction for service not been done yet.
Lordship, this is my application. Here the restoration application. Earlier the restoration applications had been served upon the state respondents, but your lordship had been pleased to direct me to serve again, along with a copy of the writ petition, but it could not be served. Your lordship kindly grants me 2 days time to complete the service.
Copy of the, here my lord, I find the, your lordship can pass that order, my lord. Section 5.
5 and restoration.
Section 5. Section 5, then section
There is a
5.
section 5, your lordship.
Learned Advocate, you have a copy?
I'm
You are
not-
carrying a copy? Hand it over to Mr. Dey. You'll find
Kindly grants me 2 days time, your lordship. I shall serve it to
on 2nd January I have passed order. In the meantime, you have not served.
Lordship, my instructing advocate, the copy of the writ petition is lying
Learned
in the
Advocate,
Section 5 office.
for the petitioner seeks accommodation to serve. Submits that pursuant to order dated 2nd January 2025. The copy of the applications have not yet been served. He undertakes to serve within a short period. Let such copies of the applications be served upon the learned advocate for the state. Next line, Mr. Chondi Charan Dev, learned additional government leader, seeks to file opposition to the application for condonation of delay and restoration. Such affidavit in opposition to the applications for condonation of delay and restoration be filed by the state respondents within 2 weeks from date of service of the copy of the applications. Reply thereto, if any, be filed within a week there. Place this matter after 3 weeks.
Grateful, your lordship.
item number 3,
Proceed this
And,
one.
very upset I submit, my lord. We have already informed the learned advocate for the petitioner that hearing has already been taken, where
Hmm.
2 persons were absent. However, my lord, we will have to pass a rescind order. Lordship kindly give some time so that in the meantime we will pass rescind order as per your lordship's order.
File a report on the returnable date.
Compliance report I will file, my lord. 4 weeks time may be given. In the meantime, we will.
Mr.
Pratik Kumar Chatterjee,
Pratik Kumar Chatterjee, learned advocate,
senior advocate.
learned senior advocate. Congratulations. Learned senior advocate representing the.
দিয়ে দিচ্ছি আপনাকে এই নেম সই করা কাগজ তো এই নেন।
You are for state and Mr.
Lordship.
You are for state
Lord.
and you are for the Gram Panchayat.
Contempt, প্রধান
Appearing for respond number 4, no?
Four.
4. Hijol Gram Panchayat informs the court that steps have already been taken and as per direction of this court, the representation of the petitioners will be disposed of by a reasoned order within a short period. He seeks 4 weeks accommodation to comply the order of the court. In view of such submissions,
জানেন না,
respond number 4
দিকে খেতে দেবো না।
is directed to comply the order within the returnable date. Learned advocate for respond number 4. No, respond number 4 for them. Respond number 4 shall file a compliance report on the
Alleged
returnable date.
contempt. Alleged contempt number.
Alleged contemner, respond number 4 shall file a compliance report on the returnable date. Place this matter on
Return in
Okay, this is a very unfortunate thing. The question was qualified or not, in the past or not, I don't. The data communicated to me, very, yes, but unfortunate that.
No, my
It's not
learned,
normal, I
my
think,
learned, no, my learned friend
Well,
send
I'm
a
also
notice for
created-
contempt.
created
Reply will be
distance.
given to the learned advocate.
Created
Why
distance
is client?
created police, not-
এটা কোনো কারণ হলো নাই।
But this is the letter, this is a Pradhan.
what has been written.
My lord, innocuous letter, my lord, just informing some thing, my lord, state of affairs.
That they have
Your
taken
lordship
already.
analysis, my lord, there is
No, see to it that this
no
is
derogatory
that-
remarks or
I do not find any.
no derogatory statements or remarks.
No, as my
But
learned
while-
friend send a notice for contempt, that's why a reply was given to him.
this only, this.
That we have already taken hearing. What is our fault? Nowadays, this is going, you have make a statement that he is he has illiterate. What she have done wrong?
And then without bypassing the law, without bypassing the.
She stated each and everything to the learned advocate.
Created a disturbance between the.
My lord, I didn't find any derogatory
What she-
statements in this
What
letter.
she made?
Since your lordship has directed my learned friend's client to file an compliance report, he would file without stating all these things. Your lordship should not
Okay.
take
Okay,
it-
first week এ দিই।
জানাবে, কাকে
take this
জানাবে
into
দাদা?
account.
4 week হলে কবে যাচ্ছে দেখো 4 week 10th February 10th February
অস্ট্রেলিয়া করে।
3 তারিখ 4 3 4 দিয়ে দিয়েছি তো নাম really?
Malar, will it be possible to avoid third week, second week? Malar, yes, second week, one of my relatives marriage, that's why. Third week, if your lordship,
10th পরে 12 দেখো
third week, my lord. I'm praying for third week. On that week, my lord,
17
Well.
sir 17th
I'm grateful, my lord.
Strictly compiled.
no we'll see on that
I
what
will,
they are doing we'll see
I will, my lord.
Actually, he is not.
I
the
assure
owner.
my learned friend, I will.
Stated he is not the owner, but.
let him come up with next
Item number 4.
For in this matter, we are able to appear on behalf of the petitioner before your lordship. We are pursuant to your lordship's order, my lord. Already exception I have filed to the report submitted by the Howrah Municipal Corporation, which has been merged now with KMDA. Lord, those are lord, on record already. I have submitted before your lordship. The case of the writ petition as such, the property in question which was thought to be acquired,
6
that is not in the year 1979-80,
Huh.
being number 145 of 1979-80. So, what is the case of the petition as made out? Although the acquisition proceeding was started, that has not been completed with the span of 44 years, my lord. So, my prayer was before the competent authorities to release that property from the acquisition proceeding, as this is not at all now necessary for the purpose for which it was sought to be acquired. And I submitted that. I submitted an application under the Right to Information Act 2005 on 20, that is on 9th December 2016, my lord. And your lordship kindly have a look to page 45 of my writ petition. Annex P6.
my lord we have the vacant land due to poison
What was the reply on behalf of the special land acquisition officer? Howrah Improvement Trust, my lord, I have annexed that, my lord. Thereafter, my lord, I have filed this writ petition. You also kindly see. 29th, my lord, January, most probably, my lord. 2016.
So what is there remaining there in the proceedings? What has been declared in 1986, possession
And
taken.
your lordship kindly have a look to that. No, nowhere your lordship will get the date of notification, date of declaration. Nothing is there, my lord. They have purposely, my lord, they did not supply that, my lord. Purpose more motivated with them. That is what my submission was. That this proceeding has elapsed in the meantime.
If there is no notification, there is no question of lapse of proceedings.
No, my lord, notification is not required, my lord. If the proceeding itself initiated in the year 1979-80, my lord, and has not been disposed of as yet, at that part, my lord, my property has not been taken over. As they have stated that we have already taken over possession.
There has to be some notification prior to declaring of the award.
Yes. That is not what they have discussed when they have done it.
Land development.
Page 45 is very important document submitted by Special Land Acquisition, supplied by Special Land Acquisition Officer, Howrah Improvement Trust. My submission was, my lord, before your lordship, my lord, they should supply the date of notification under section 4, under section 6 of 1894 Act. That is not here. And from report, your lordship will find also, my lord, the exception I have taken. Reform report submitted by the respondent number 2, 3, and 4. Your lordship kindly have a look to. That is on record. Page, my lord, 8 of the report. Page 8 submitted by, my lord, the respondent number 2, 3, and 4. Your lordship kindly have a look to. All are blank.
Exception report of
Report of, my lord, respondent number 2, 3, and 4. That is Land Acquisition Authority, my lord.
what is blank? 8 is
That is report, my lord.
Report page 8, your lordship.
report.
All are blank. Notification number, date, blank. Published at page of the nothing. Declaration, no date. So, my lord, how, my lord, that will be determined when they have filed notification, published notification under section 4(6). But if it is found from records that after the declaration was made under section 6, within 2 years, they will have to, my lord, award has to be, my lord, declared. That has not been done here. We are not getting the date itself. When the section 4 and section 6. It was, my lord, sought for acquisition, my lord, under the 1894 Act. So, my lord, those two dates are very much necessary for, my lord, taking consideration of the prayer of my petition of Imperial Lordship.
Yes.
I will read it.
She is concluded.
My lord, I have a KMDA, my lord. My lord, Mr. Basu is, Colonel Basu is appearing in this matter. My lord, may it be short pass over, my lord.
State. Where is
For
it?
state, I understand Mr. Chondicharan De was appearing for one time.
Mahato is appearing. Where is he? Where is he?
But I have taken this point. We also will find from my exception, my lord. I have taken this point and also made submission before the honorable court, my lord, where it was appearing before the coordinate bench.
So your only grievance is that no notification under 4 or under section 6 of the Acquisition Act 1894 has been published.
My lord, your lordship. And possession has not been taken. And also payment has not been made.
Possession has been taken.
No. I am in possession, my lord. Your lordship kindly have a look to my read petition, your lordship kindly have a look to. Your lordship kindly have a look to page, my lord, 45. Page 45, I shall place before your lordship to show that possession has not been taken.
Possession taken in the year 1990.
Yes, your lordship, that is why, my lord, your lordship kindly come to page 45 at paragraph 7. Sorry, my lord, paragraph 5, my lord, paragraph 5, I'm sorry, my lord, paragraph 5. Page 45, paragraph 5. Possession in respect of vacant land measuring an area of 1 bigha 13 kata, 1 chota was taken leaving an area. My lord, this is my lord, submission. Leaving an area of 8 kata, this is my lord, my property. This is my property and still in possession there.
Hmm.
This is merely paper transaction, nothing more. They have admitted that leaving that area. And this is my property, which is my lord, under consideration before your lordship.
You were enjoying the land.
Without my lord, possession has not been taken over, and also no payment was made, my lord. Which is clearly, my lord, applicable under my lord, under section 24 of the 2013 Act.
Then what is your grievance? You are in possession enjoying the land.
Yes.
Land has not been.
Unless it is released, my lord, I cannot be able to, my lord, enjoy the property without free from all encumbrances.
So your land was never under the acquisition. So what is the question of releasing the land?
But what I am, my lord, that was included in the acquisition proceeding. It was
First, you say
included.
that there is no section 4, section 6 notification. Right to Information Act, information has been given that your land has been left out. Now
Very
you
well.
of the
If your lordship so kindly, your lordship kindly pass such order, I am nothing to submit.
what order is court to be passed. You say that you are in possession of the land. There is no acquisition in respect of your land. So what remains? You are enjoying the land.
My lord.
Then-
And I have, well, that apartment I have been giving the my lord, rent also, government rent. They are receiving that. My name is appearing in the record of right till today.
Your land has never been encumbered. Where is the encumbrance by the state? The
No,
state
no,
says you have
nothing,
left out.
no, that is not. As the land was included in the acquisition proceeding, that is why my grievance. Otherwise, not meter. No problem.
So how do you come to know that your land has been included? You say that there is no section 4 notification, there is no section 6 notification. How come
My
you come to this conclusion that your land has been acquired? Right to Information Act says that your land has been left out. You also concede to that you are enjoying the property.
Yes, my lord.
What is left in the writ petition?
And my record of right also, your lordship will find my name is appearing in the record of right, Miller, till date. Which is, I have annexed with the Miller copy of the exception, your lordship kindly have a look to. Exception on affidavit, which was affirmed by my client on.
Then what is your grievance, madam?
As my land was within the acquisition, within the schedule of acquisition proceeding, Miller, that is my grievance, nothing more, Miller. Record of right will show my name is appearing in the this is the plot information report submitted by the petitioner before your lordship at page P4. Your lordship will find everybody's name are appearing as Rayat Miller, and such plot information was supplied to the petitioner by the block land and land reforms officer. I am telling your lordship. And I have been giving rent to the state of Assam, they are accepted. But this is 2015, your lordship kindly come to page 42. 42 is, this is a report dated 9/6/2015. And it was started in the year 1780. All are not eligible copy, but page 42, your lordship will find that was officer authorization of section so-and-so was supplied to me on 19th June 2015. And from the rent receipt, your lordship will find page 43, bottom 16/6/2015. So everything they are taking from me, treating me as riot. But my name, my property was not involved in the acquisition proceeding. This is my only grievance, nothing more.
What is the name of the petitioner? Kashinath Das.
Kasinath Das and others. The owner of the land, my lord, had died long back, my lord, 2001. We are the, my lord, successors. Page 45 is the, my lord, their document, they have, my lord, taken over possession, and property is question is also involved. Why I tell of lordship, this is my property. Paragraph 5, possession in respect of vacant measuring so and so, my lord, and last year was taken over. Area of covered structure possession was of 90. 8 case of was covered by structure. 5 and 6 both says that this has not taken over. LA case number 145 of 1979, that's 80. Well, it was the land was involved. That is why I make a prayer with there, beloved.
Mr. Mahata has come. Mr. Mahata has come. Okay. Smriti on Monday. Not today. But
Very grateful, deeply appreciate your lords.
next.
Item number 5.
I am appearing on behalf of the petitioner, my lord.
Be presented.
One scheme was introduced by the Kolkata Metropolitan Development Authority. The scheme is the particular area development project. In that project, my lord,
You have filed your affidavit.
one plot.
KMDA has filed the affidavit.
There was no direction. Well, this issue here,
My lord,
this is not the scheme. What happened? A plot of land was
my lord,
a plot of land was allotted in favor of the petition on leasehold basis, subject to certain terms and conditions stipulated in the lease deed. Amongst all other conditions, there was a condition that within 5 years of execution of the lease deed, the allotee will make construction in accordance with.
within 2 years. That is
As it-
20.
My lord, within the stipulated period, construction could not be made by the allotee. The authority called him for hearing because on failure and within such time, my lord, till he was called for hearing, no prayer for extension was also made. So the authority called him for hearing. At the hearing, he represented and submitted reasons which appeared to be not satisfactory. So for breach of these terms, my lord, the consequential effect is the cancellation of the lease, the allotment, and resumption of land. My lord, to save cancellation, my lord, at that point of time, the authority had framed a, my lord, policy to save cancellation, to revive that allotment. My lord, he has to pay the penal charges. Demand was at the hearing, at the time of hearing, he agreed to pay the penal charges. But later on, when demand was issued, he refused to pay. A final reminder was given to him,
Okay.
but he has not paid. And challenging that demand, this writ petition has been filed. My lord, this issue is no more res integra, my lord. This arose in some other cases, my lord. The coordinated bench, my lord, rendered judgment in our favor that authority has the power. It was then appealed against up to the Supreme Court. This has been affirmed. So I will be relying on all this. My lord, exactly the same issue. There also the lease deed executed within the stipulated period. The lessee, the LOT could not make construction. He was also called for hearing. Penal charges were imposed, did not pay, and challenged that demand. That authority KMD didn't have that authority to charge penal charges, as the penal charges is not contained in the provision is not contained in the lease deed. But the writ petition was dismissed. It was rendered in favor of the authority. So it is affirmed up to the Supreme Court. I'll be relying on that. So since, my lord, no affidavit has been filed, my lord may grant us liberty to use affidavit, and then the matter can be heard.
My lord, may I submit one thing, my lord?
No.
My lord,
Mr.
may I submit one thing, my lord? Filing of page number 20, my lord.
Mr. Tottujit Talukdar,
Page my
Learned
lord,
advocate
may
appearing
I
for
submit one thing, my lord?
KMDA, respondent KMDA,
2 to 6.
2 to 6.
2 to 6.
2 to 6. Submits that. The respondents
My lord,
needs to
ground is not that, my lord. My ground is that, my lord,
requires
that
to
delay is not
file
on my cause, my lord.
an affidavit in opposition against the writ petition. Let such affidavit in opposition be filed by respond numbers MDA within a period of 3 weeks. The reply thereto, if any, be filed within a 1 week. Is this matter after 4 weeks. Next.
Item number 6.
My lord, Mr. Supratim Dhar appearing on behalf of the state. My lord, he's on legs in some other court. I'm kindly praying for
A new junior is yet to be appointed.
Before occasion, the matter was adjourned.
What is this case?
Lord, the state utilized my land. From the inquiry report, it reveals. Lord, I am praying for compensation in respect of the land utilized by the state. First, my lord, I filed a writ petition in the year 2017. That writ petition was disposed of by this honorable court on the ground that is with the liberty to file a fresh cause of action. Since the state contention was that for the construction or to repair the damage part, they are doing so. But that writ petition disposed of 2017 is disposed of with the liberty to file that writ petition with fresh cause of action arose. That was appeal against the honorable division bench dismissed the appeal since the liberty was granted by the learned single judge. Now 2019 I filed another writ petition, but since there is no phase of cause of action, this honorable court dismissed the writ petition with cause. Now, in connection with that 2019 writ petition, after disposal of the writ petition, they conducted a joint demarcation, joint inquiry, field inquiry, and the inquiry report was served upon me. From that report, it appears that some portion has been land utilized by the state for the embankment of the river.
Now, after obtaining that report, I prayed for compensation. Now, this is a fresh cause of action, and I pray for compensation. Kindly stated comes to page 23 of my petition that the demarcation of land report is this is the state cannot deviate from their stand in that report. The address to the petitioner page 23.
Page 45.
The page 23, this the short issue is involved in this page 23, the joint demarcation the report, page 25, the 23 is the forwarding letter, page 26, the third paragraph. Enclosed please find here is the land plan 2 sheets showing details of the plot bearing such and such. River such and such, out of which an area 0.30449 acres marked red color A is such and such per total area plot is lying within the details distribution. Well, this is my case. Well, my land has been I have annexed the sketch map also, and the page 29. On the basis of that report, the representation made before the concerned authority, page 29. 29, the last part I have written that from the said demarcated program, it is found that 0.3 acres of our royalty land forcibly occupied by the irrigation department without any notice of the landowner. So since the state has utilized our land, I am praying for compensation, no proceeding for acquisition and requisition was made. That is the sum and substance of my
The state has filed its
opposition, state file opposition. We have also used the reply. In state opposition the copy of the opposition has been served upon.
Where is the opposition? Where is the opposition? Opposition to me.
I don't kindly
it is opposition to me. নিলাম কি করে বলে তো হাজার বলেও নেই যে অপোজিশন না থাকলে রিপ্লাই আসবে না রেকর্ডে তাও দিয়ে দিয়েছে দেখিনি নোট করে নিয়েছি স্টেটও বলেনি
most probably they did not file the opposition.
So what was the use of filing an affidavit in reply?
So they said the last occasion they shall file their opposition. The next day, for that reason my lord recorded filing our reply.
Now what is your submissions?
kindly make it not today, my lord. He is on legs in some other court, my lord. And
Monday come.
as far as I came to know that no junior advocate has also been appointed to.
On the last date he submitted that he needs a junior. If it is not appointed, you are not the appointed junior.
I am not in the state panel, my lord.
Ask him to remain present Monday. Monday
Instead of Monday, twist. If possible.
Learned advocate, Miss So-and-so, learned advocate, representing the state respondents, seeks accommodation. List this matter on Friday release. Department is directed to furnish a report as to whether any affidavit in opposition has been filed by the state respondents on the returnable date. Asking a favor. Wait, representing করলাম বা appearing করো appearing for this two. 6th February. 6th February.
Grateful Lordship.
Item number 7,
I'm
7 and 8.
I'm sorry, but I apologize. But the other day I was not here. I was appearing before another court. I couldn't
Yes.
make it up. I'm very sorry. But on the last occasion, I was submitting about equity and the directory provisions. Now, if your lordship kindly comes to this judgment of the Honorable Supreme Court, Dove Investments, 2006 to SCC 619. While construing the provisions, and I'll soon come to Rule 32 after this, I've already shown your lordship that in one provision there can be a directory and a mandatory provision. Now, I'll press that point further. If your lordship kindly comes to paragraph 13 of this judgment. There was a query from your lordship. What will happen? What will happen if things are going like this? Now, if your lordship sees this judgment, it'll make something very clear. Paragraph 30. 1.3. Paragraph 13. Whether a statute would be
Yes.
whether a statute would be directory or mandatory will depend upon the scheme thereof. Ordinarily, a procedural provision would not be mandatory even if the word shall is employed therein unless a prejudice is caused. Now, no prejudice has been pleaded in the writ petition. None of these writ petitions. Nothing, no prejudice. That only these gaps are not there, that's all. Now, thereafter, paragraph 14, Millard. In Chandrakant Uttam Chandonkar versus Dayanand Raju Mandrakar. The court, in this case, it is not necessary for us to go into the question as to whether section 83 is imperative in character or not, inasmuch as it is settled law that even whether the expression shall is used, the same shall not be held to be mandatory. Even a mandatory provision having regard to the text and context of the statute may not call for strict construction. I've said this before, if your lordship sees from Bennion as well as from Wade. These things, rigid constructions, they said. Now, this is what the Supreme Court is saying here. Ordinarily, now 75 after that, then after that I read on minute. Ordinarily, although the word shall is considered to be imperative in nature, but it has to be interpreted as directory if the context or the intention otherwise demands. Now, I'll show your lordship that the context or the intention otherwise demands. That is what I will be on. Now, thereafter, it is important to note that in Crawford on statutory construction, it is stated that miscellaneous implied exceptions from the requirements of mandatory statutes in general. even where a statute is clearly mandatory or prohibitory. Yet, in many instances, the court will regard certain conduct beyond the prohibition of the statute through the use of various devices or principles. Most, if not all, of these devices find their jurisdiction in considerations of justice. It is a well-known fact that often to enforce the law to its letter produces manifest injustice, for frequently equitable and humane considerations and other considerations of a closely related nature would seem to be a sufficient caliber to excuse or justify a technical violation of the law. Now, Millard, they waited. My plan was sanctioned 2018. I built. The whole structure was complete. 2023, they come before this court 5 years later. Already the structure is complete. Manifest injustice for technical reasons. Then, now, if your lordship sees, recently a 3-judge bench in Kailash versus Nanku, while interpreting order, I need not read any further. Then after that, paragraph 17. Paragraph 17. However, even if a statute is directory in nature, the same should be substantially complied with. What would satisfy the requirements of substantial compliance, however, would depend upon the fact of each case. 18. Thereafter, the appellants do not state as to how they would be prejudiced by the act of respondent number 1 in not filing the application for registration of transfer of shares within the aforementioned period. That is what I was really hinting on throughout my arguments, Millard. On thereafter 19, on their own showing, thus, they were not prejudiced. One of them says that the railways should have, the manual of the railways is binding. He doesn't show any prejudice. And the other says that side spaces were not open. But I have already shown before Lordship that the non-obstante clause says that there is adequate side space. Non-obstante clause there I pointed out. Now, on their own showing, saying, thus they were not prejudiced. No pleading of any prejudice in none of the writ petition. Now, thereafter, Millard, if I may kindly come, if your lordship kindly comes to the rules. Rule 32. আছে রুল আছে একই তো এটা ছাড়া কিছু নেই
Rule 32.
মিউনিসিপাল বিল্ডিং রুলস মানে একই আমার কাছে দুটো কপি আছে নিতে পারি পেজ 40 হবে 41 40 with this, your lordship will have to read this particular rule with the amendment which was done by a notification. That is before your lordship, that notification which was handed over before your lordship. 28 July 2023.
27th July.
Minus 28 July. Yes, 27 July. That's 27 July. Your lordship is absolutely correct. Notification 27. Yes, 27 July. Yes, yes. That.
Yes.
Now, if your lordship sees, your lordship, this is amended now. Amendments. And this is what is actually published. This is what I was throughout telling you submitting before your lordship. This is in the Calcutta Gazette. And a notification must be brought into existence. This is the law. It has to be brought into existence like this, not by a manual. Anyway, Millard, that is beside the point. Now, if your lordship kindly sees this, in the said rules, after proviso to sub-rule 2 of Rule 32, add the following proviso. Provided further that the Board of Councillors may by order regularize the minor unauthorized erection or execution of any minor work without sanction under these rules or minor deviation from the sanctioned plan or I'm reading the notification, from the sanction plan or execution of any minor erection or work in contravention of any sanction plan under these rules, keeping regard to the following things, as the case may be, on payment of fees, charges by the person responsible for such portion of minor unauthorized erection at the rates as may be determined by the state government by notification. Now, 1A, objections raised by any local inhabitants of the construction in question. Now, the first writ petitioner before your lordship might fall into this category because he doesn't have a house there. He's not an owner, as I've said, but he says that he lives there. So he might just come into that. Road width and communication facilities, drainage system of the surrounding locality, other civic infrastructures, clearance from the Fire and Emergency Services Department and Pollution Control Board, if required. Railways not here. Your lordship will kindly note, railways are not here. Reasons beyond the control of the person responsible. Social interest, facilities of an ingress and egress, infrastructural supports at site, structural safety, environmental aspects, national loss in case of demolition, availability of other statutory clearances as will be required, etc., with due regard to the spirit of law, any court order as well as provisions of the West Bengal Municipal Act. So statutory clearances are not provided, railways are not provided the statutory clearances. And because it is not a statutory, as I've shown your lordship, it is not a statutory provision at all. Now, if your lordship sees this,
Yes.
now, if your lordship sees this, I'm talking about the objectors, the writ petitioners. And if your lordship kindly comes to page 57, I'll repeat once more, page 57 of the building rules. That is the note
Yes.
50. Rule 50. Note 3. Notwithstanding anything contained in clause A of subrule 2, the minimum distance across the site's open space from every new building to an existing building with a floor, with a door or window opening shall be 1.80 meters. I've cleared more than that. So the first objector here
Yes.
the first objector, that is the first writ petitioner, he's got nothing to say because I've left that statutory open space here. 1.80, I've left more than that. So his grievance is taken care of by the municipality. It need not hear him anymore.
So as per you, if there is any deviation on the other sides, supposing in front, in the other side of the building, since the petitioner is not prejudiced having his building on his side, he cannot raise the issue.
He's not affected because this is what the rule says. The rule says this. The municipality takes care of the others. He can raise his voice if I'm too close to him. And the other one, the second writ petitioner, Second writ petitioner is WPA number 29103. 29103. Now, if your lordship kindly comes to paragraph 7.
Yes.
Yes, paragraph 7, if your lordship sees, that your petitioner state that the private respondent numbers 9, 10, and 11 are constructing G+4 multi-storied building in the said landlord's property land just side of the petitioner's land and house in question without leaving required side space, i.e. 4 feet from both sides of the petitioner's land in question. Now that has been addressed. If your lordship kindly sees the report of the municipality, I've left more than that. I've left more than that. The court's order was, see whether this is done. And there is no deviation in the report that has been submitted before your lordship. No, it's the same, one report.
At that time, when the first writ petition was pending, at that time, the second writ petition was not appear. So therefore, there is no question of filing the report in 2 matters. Because both the matters are different, my lord. One is against the illegality and another is against the railway track.
If it shows that there is side space of more than 4, they can't have a grievance. A second report need not be called.
No, his building is on which side of this particular building in question? Not left, right, on the western side.
Yes, this is. One side here. One side here. No, this is not the word. This is the. Give me the report of the municipality to the first writ. Western side. First writ petitioner. First.
Side of the
Reply. Right to the old Modi. First writ petitioner reply to Modi. No, এটা নয়। দাও না, ইয়েটা দাও না, রিপোর্টটা দাও না। show.
I have annexed the map.
No, I'll go to the map also. I'll go to the map. I'll go to that.
Entrance is 4 feet only.
He's got nothing to do if my entrance is even 2 feet. That's for the inhabitants to say. People who are buying the flat there. What does it matter to him? And normally he's not affected if it's even 2 feet. And the inhabitants, the buyers, they say that we are happy with 2 feet. It's not spilling onto the road. It's got nothing to do with him. No, that is why I'm showing your lordship that the prejudice must be shown. That is the pith and substance of my argument. And that is what the Supreme Court says. That's what the interpretation says. It's not mandatory. Now, if your lordship kindly sees this report, the site inspection was carried out in presence of petitioner Polash Dash, respondent proprietors and landowner so and so. The findings are based on physical position of the building in question. Physical position of the building in question as per sanctioned building plan of the above noted holding. The details of sanction plan, building plan are as follows. Petition number of the plan is 688 of 2018-2019 with a serial number BOC 8 corresponding BOC meeting dated 31/8/2018. Sanctioned by Sirampur municipality, and the said sanction was extended up to 10/10/2023. Site spacing towards the petitioner's house eastern direction is 6.7, which is more than the sanction plan, up to a stretch of 22 feet from the southern or northern side. Then it turns out to 6.2 for a stretch of 20 feet, and the remaining 11.5 feet. The measurement turns out to be 5 feet open to the sky, which is more than the specified spacing of the sanctioned plan. So I have not deviated. It is there. And they have not challenged the jurisdiction of the municipality in sanctioning this plan. And I'll come to another point where they have not even made the landowner a party. I'm just a developer. Without him, he's the person in whose name the plan is sanctioned. They have not made him a party. On the western side, on the western direction, there is a spacing of 10 feet from the ground floor throughout, which is as per sanction plan. On the northern direction towards the municipal road, there is a spacing of 4 feet in the ground floor and approximately 2.10 projection from first floor onwards. I have shown your lordship that cornice and chaja. I've shown your lordship that after 10 feet, I can up to 2.5 feet. That is also there. On the southern direction, there is a 4 feet side spacing as per sanction plan. So all the sides are taken care of by in this report. And a second report is not at all necessary because it covers everything. And in paragraph 7, he says 4 feet. 4 feet without leaving required side space of 4 feet from both sides of petitioner's land in question. So he's happy. I've left more than 4 feet. 11 feet.
11 or 10?
Yes, 10. And thereafter, the next one, the next paragraph, which does not concern him, but he pleads it. It has replied about opposition. तो তোমার দরকার হলে তুমি ভেঙে দেবে পাঁচটা তো খাবে আমার মুখ
Yes.
Now, if your lordship kindly comes to paragraph 8 of that writ petition. Well, I'm doing a conjoint pleading because so that time is not wasted. Thank you. Now, 8 is your petitioners state that it also appears from the record that the entrance of the multi-storied building is only 6 feet from right side of the multi-storied building, where entrance is only 4 feet. Now, as I've said, Millard, and as was being pointed out by my learned friend just now, what does he have? What does it matter to him? Entrance is the inhabitants who are going to enter. I'll certainly not allow him to enter. But about the inhabitants who are going to enter this building is 4 feet. They're happy with it. It's a minor deviation. And that is why 32 has been given. 32, I've shown your lordship that notification. And that is why I've cited that judgment of before your lordship. And then he says about the railway track is only 7 feet. And I've said that he is himself only 3 feet away from the railway track. And thereafter, Millard, if your lordship sees, this is very interesting, where these two writ petitioners, because this was pleaded before your lordship, it was submitted before your lordship, paragraph 11, that your petitioners state that the said private respondents also leaving without required size space from another house, i.e. Thakurbari construct, this is the first writ petitioner where he stays, i.e. Thakurbari constructed multi-storied building where the inhabitants of Thakurbari also residing permanently for last 60 years. He espouses the cause of the Thakurbari as well, without showing what his prejudice is in this. How is he affected? And I've shown your lordship that there is enough gap. So these people are working together. Now, if your lordship kindly comes to my affidavit in opposition filed to this second writ petition, para 11 and 12 and 16, because there is a deep nexus between these two people. I've got an injunction against one of his relatives. I filed a civil suit, which was, it was said that when I filed the civil suit and when I came up before this High Court, that the order of injunction did not subsist. But contrary, I'll show your lordship that it did. The rule has been made absolute. Now, the relative who has been injuncted, he comes up through another one. This is what I've said. Now, if your lordship sees paragraph 11. And this is uncontroverted. Reply these.
Yes.
Statements made in paragraph 21 and 22 of the writ petition are matters of record. It is stated that we have not made any illegal construction whatsoever, and the petitioner has filed this writ petition by suppressing the fact that we have filed titled suit number 667 of 2022 to prevent Shubhola Pandit from causing trouble when we have been constructing our building according to sanction plan. Incidentally, Shubhola Pandit is related to the present writ petitioner. The present writ petitioner is also a defendant in the title suit. Your lordship sees this. He is also a defendant in the title suit filed by us. And there is an order of injunction restraining the present writ petitioner from disturbing our right to construct. He's been causing trouble throughout. The order was passed by the learned civil judge, Junior Division, Second Sirampur, Second Court, Sirampur, Hooghly, entitled suit number 667 of 2022, dated 23/12/2022. The order of injunction is made absolute on 31/10/2024. The last submission that was made on this was that the order of injunction did not subsist. Now, if your lordship kindly comes to S3, the order of the Honorable Court, of the learned court below. Page 16. So after I get an injunction, they come up before this court. I'll take care of that also in another judge. That the injunction petition under order 39 rule 1 and 2, read with section 151, filed by the plaintiffs, is hereby considered and allowed. And the ad interim order being number 2, dated 23/12/2022, is hereby made absolute till the disposal of the suit. Hey, wicket which? No, municipality.
At
No,
the time of filing their opposition, Jansen order has been vacated. In our opposition, in the prior decision, we relied on the order states. But and Mr. Mukherjee was it's the Jansen.
Good.
That is why Mr. Jansen. But in my opposition, there is see certified copy of the order sheet showing that their Jansen was vacated at the time of filing their opposition. I can show.
This has been made absolute.
It afterwards after time of filing their
It was pending there. It was pending there.
That was vacated. I have submitted certificate of copy of the order sheet. I can kindly take up my opposition.
On instructions, Millard, I submit that this has been made absolute. And the suit is pending. And this person who's filed the writ petition is also party there. What is the bullshit? This is second writ petition. Why are you?
Second petition, nothing has been mentioned in the writ petition that the suit is pending.
No, they've not.
Municipality authority is not a party of that suit, my lord.
They've not said anything. That he is a defendant in the suit. Not said that.
Your affidavit in reply.
Millard, I fail to understand. The first writ petitioner is not concerned. I have not taken an injunction against him. Now, if your lordship sees, he's espousing the cause of the second writ petition as well, and the second writ petition is espousing the cause of the first writ petition. Now, how do I, Millard? How do I plead before your lordship or argue this? No, it can't be a similar cause. It's your writ petition. You have not said that. It's not. You're not hurt by it.
25 of my affidavit in reply. Affidavit in reply.
But just submitting one thing, my subject to lordship permission. My lord, the building which has been so-called building, that is holding number 12. And the first writ petition is 11.
You will make your submission. Let him come. Yes, page 25 of the opposition. There is a order.
At the time of filing of this opposition.
Subsequently, it was made absent. What difference does it make? And it's not his case. I have not said that he is a party to that writ petition. I have not said that.
Yes.
Rather, now he's taking up the cause of the second writ petitioner. Without showing the. So both of them on both sides, they don't want this building to be constructed. They come up with causes which are non-existent. Does not hurt them. If your lordship sees, the next date is pending issues, is for framing issues in the suit, in this civil suit. It's just now I found that out. Now, if your lordship sees, the map is before your lordship. The sanction plan. Now, the area statement
Yes.
The area statement, if your lordship sees, if your lordship compares, and I've asked the engineer to talk to me who had drawn up this plan, because they are doing this for all municipalities, for all buildings that side. They're qualified. We are not qualified to do that. So they know the rules of the municipality and how much of concession they get and how much of building they can make on what covered area. Now, if your lordship sees that this is the total land area is 6 kathas, 6 chotaks, 30 square feet. Broadly, I'm saying this. The ground floor covered area is 240 square feet. Ground floor covered area commercial is 31767, 294. First floor covered area is so much so. All this comes to less than 60% of the covered space, covered area that I'm entitled to. Less than 60%, a bit about 60% of the area to which I'm entitled. Now, 65% is to which I'm entitled, that if your lordship sees, rule 646. 46. No. Rule 46 is at page 50. Page 50. Plot size up to 200 square meters. That's what I am. Between 200 square meters to 500 square meters. 65% covered maximum permissible ground coverage. I'm 60%. 5% below. They don't take chances. These engineers. They keep, suppose there is a need, you can go in for that 5%. They're qualified engineers. They're doing this every day. We don't have the technical knowledge of these engineers. So one thing is, if your lordship sees something very important here is that they have a right, they have definitely a right to come to court, to espouse their cause, but I have an equal right to build. Person has the liberty to do whatever he wants, as long as he does not infringe upon another's rights. And that's what they are calculatedly doing. One of them is a defendant in a suit. He was causing trouble. He was injuncted, and he comes up before your lordship. The other says that there is no boundary declaration. He says that I have suppressed something, but he's not the owner of the adjoining land. How does he know? What is your land? Have you come up with that? That this is the boundary of my land. My land is this much. It's 8 kathas.
6.
His. I'm talking about his. The Thakurbari.
Okay.
He doesn't even know. He comes up as a local inhabitant. I'm staying there.
Yes.
On this, Millard, that equitable principle, this is beautifully put, Millard, and your lordship, this is one of the beautiful lines which I've said. But I'll just wind up with one more. Any other point? Oh, the judgment. I'll hand this up. Your lordship. This is from Benjamin Cardozo. This book.
उड़े ना जाएगा. Yes.
Benjamin Cardozo, he says something that's very, is absolutely germane to what is being said. Not if your lordship see page 39, about among the moderns, Spencer announced a formula of justice. Every man is free to do that which he wills, provided he infringes not the equal freedom of any other man. This is what they are denying me. I'm doing it according to law. Now they cause trouble. I got an injunction. Now they come up before this court, pointing out frivolous things which actually don't concern them. Now, before I end, Willard, this is Arekta Jinis হচ্ছে এইটা. I'll hand this up before your lordship. And the others also I'll hand up the other judges.
একটা compilation করে দিয়ে দিলে give a compilation of the other day you have referred to some of the books with
Yes.
pages, make a
I'll-
compilation of the judgments.
This one I've handed up just now. Now, if your lordship sees, they were first and the second writ petition are both conjoined, submitting before your lordship. About 217 of the Act, section 217.
Act of West Bengal
Act,
Municipal.
একটাই আছে আমার কাছে। Act, act. এটা দেখ।
Municipal Act 1993.
রাহুল, তোমার কাছে আছে? Act. রাহুল,
Give a এটা আনিয়ে দাও একটু। এই একটা আনিয়ে আপনারা রাখেননি এটা ওয়েস্ট বেঙ্গল মিউনিসিপাল অ্যাক্ট
আছে
আছে তাহলে ঠিক আছে রাখুন দিয়েছে যখন দেখি yes 217
Yes, if at any time sanction or provisional sanction to erect any building has been given by the Board of Councillors is satisfied that such sanction was given in consequence of any material misrepresentation or fraudulent statement contained in the plans, elevation sections or specifications or land or any material particulars submitted in respect of such building, it may cancel such sanction and any work done thereunder shall be deemed to have been done without sanction. This is not attracted. Your lordship sees from the report, they said it's according to sanction plan. Number two, they point out the main thing why this was pressed into service before your lordship was that that 30 feet from the railway line that was suppressed. Now, nowhere in the act or the rules your lordship has not found that I have to get any permission from the railway authorities. And I've shown before your lordship that that is not the law. That has got no binding effect. It's got no statutory effect, not a statutory provision, and nor has not to be complied. Just a mere instruction. So that is why there's nothing. And here this is not attracted at all. Now,
one is not
the order of demolition, after that 218, if your lordship sees, this is also not retracted because of your lordship, because I have shown your lordship, if there is, though there is, the plan doesn't, the report also doesn't say so. If there is, I have already applied under 31 and 37 and 32. All those rules cover me. There is nothing called a demolition. There doesn't call for a demolition process. Now, if your lordship sees, the last thing, oh, the judgment. Judgment কত নম্বর ছিল, কত judgment ছিল? Judgment দেখ লেখা আছে এর উপরে। এই তোরা কি judgment দিয়েছিস? এই তোরা কি judgment দিয়েছিস বল? এটা দে। If your lordship sees 2012, 12 SCC 133. V. Chandrasekharan. 133. If your lordship straight away comes to paragraph 44. This is on clean hands. Our book. Volume 12, SCC 133. Your lordship kindly comes to paragraph 44.
Yes.
The appellants have not approached the court with clean hands and are therefore not entitled for any relief. Whenever a person approaches a court of equity in the exercise of its extraordinary jurisdiction, it is expected that he will approach the said court not only with clean hands, but also with a clean mind, a clean heart, and clean objectives. Thus, he who seeks equity must do equity. The legal maxim, that is Latin, means that it is a law of nature that one should not be enriched by causing loss or injury to another. The judicial process cannot become an instrument of oppression or abuse, or a means of, in the process of the court, to subvert justice, for the reason that the court exercises its jurisdiction only in furtherance of justice. The interests of justice and public interest coalesce, and therefore they are very often one and the same. A petition or an affidavit containing misleading and or an inaccurate statement only to achieve an ulterior purpose amounts to an abuse of the process of the court. In Dalit Singh versus State of UP, this court noticed an altogether new creed of litigants. This is very important. That is, dishonest litigants, and went on to strongly deprecate their conduct by observing that the truth constitutes an integral part of the justice delivery system. The quest for personal gain has become so intense that those involved in litigation do not hesitate to seek shelter of falsehood, misrepresentation, and suppression of facts in the course of court proceedings. A litigant who attempts to pollute the stream of justice or who touches the pure fountain of justice with tainted hands is not entitled to any relief, interim, or final. Now, what has he done? The second petitioner comes before your lordship and says that I have not built more, it's only 4 feet. I've not left that gap. Your lordship has seen that it's 11 feet. Number two, he says that it's not 30 feet away. He suppresses the fact that I have filed a suit against him. And he's a party to that. And there's an injunction. And the second one, and the first petitioner, he says that I have misrepresented the boundary without showing what the boundary is. What is the boundary? And he says that I have not left the gap. I have shown your lordship that I have left. So these people are not entitled to any relief. And there is an order of injunction with it against me. I have been injuncted from building. I have suffered loss. There should be something, the restitution, some compensation if I do succeed. Because I was injuncted from carrying on my business. And number three, three is that the landowner of this particular property has not been made a party. They seek to cancel his sanction plan, who's not mine. I'm a developer. He is a person without whom no decision can be taken. This, because the plan is sanctioned in the name of the owner. But not in the first one. So it goes then. The first writ petition fails. For non-joiner of a necessary party, without whom no decision can be taken. But that's all my lord. I'm leaving.
আমি লিখে নিয়ে দেবো এইসবে
I have taken time because I will not have a chance to reply. So, and they will of course just not put in anything new. If they do, then your lordship will call upon me to.
Now, my lord, I have been submitting the written submission. I don't take any time, my lord. Because the matter was pending since more than 6 months. Whether the building is, this is the first writ petition, it is submission, and this is the second writ petition, almost same but different. Difference is, my lord, this is the second written submission. And my lord, I have served the copy. So that your lordship may be, hearing may be closed, but otherwise it will be suffered municipality, my lord. Suffered in this sense, my lord, I have been, building has been sanctioned, and as per direction of the Honorable Justice Ganguly, the report has been submitted, and the direction was whether the area from the complainant and the building is to be taken out. On the basis of that direction, the municipality has been engineer, has submitted the report. The name of the owner of the first party is another person's. But that person has not made party. But I have been made in everything, my lord. Yes. But I am giving the copy, my lord. Copy of the just go দিয়ে দিচ্ছি এক্ষুনি দিয়ে দিচ্ছি And the railway tax is not a criteria because the Municipality Act is going on above the State Act. This has been constitution under Group 9. There is 3 types of act. One is Central Act, another is State Act, and another is concurrent jurisdictions. The municipality, Srinampur municipality তো 10 ফুটের মধ্যে বাড়ি হয়েছে ভেঙে দিক অফিস থেকে
on the next day, may I get half an hour time on, because on the question of applicability of the railway manual, some points have been taken by the learned advocate appearing for the private respondent. I have some points to submit.
Then again, I have to go back to him.
Because, I am the respondent. It was not a substantive.
It is not an act. Railway Act
Not
in
in
the
the
position. Yes.
Some points of law are there to submit against the points taken by me, learned friend. Kindly allow me to place those points.
Then I will allow Mr. Sannal to respond to
Yes,
that.
email, email. I have no objection. Only half an hour time, not much. I give the date on that date. I shall.
Mr. Sudeep Sannal, learned senior advocate, appearing for respond numbers 7 to 10 in WPA 10868 of 2023 and respondent numbers 8 to 11 in WPA 29103 of 2023. Mr. So-and-so learned advocate, appearing for respondent Srinampur municipality, files the written notes of argument in both the writ petitions. Mr. Pinaki Ranjan Chakraborty, learned advocate, appearing for respond number 6 and 7, railway authorities, seeks accommodation to make submissions on point of law. Liberty is granted to learned advocate representing the respondents in WPA রেসপন্স নম্বর 7 to 10 ওই যে করে দেবেন মিস্টার সান্যাল যে আছে ওটা ওখানে মেনশন করে দেবেন if required to make his points of submissions. Okay. Please this matter on. বড় খোলা ফিরে এসে শুনতে হবে হ্যাঁ এই উইকে নেক্সট উইকে হবে না 7th 8th এরকম করে দাও ফেব্রুয়ারি 7th দেখে নাও কিছু আছে কি কনক্লুড টপে দিয়ে দেবে 7th ফেব্রুয়ারি দেখো কিছু দিয়েছিলাম আমরা ঠিক আছে গ্রুপ 1 এর পরে টপে থাকবে প্লিজ দিস ম্যাটার under the heading assigned matters at the top on 7th February. This matter on 7th February. On 7th February top, whatever comes, you just give a point of your argument with regard to what is submission on that is all. And also make a compilation of
Yes,
those.
I will.
Yes. বইগুলো আছে এই
তাহলে
বইগুলো
চলো,
আনিয়ে
এখানে
list
দেবো।
করে আনিয়ে দিন হ্যাঁ
Faithful man,
দিয়ে দিন, বই
ফুটে আছি বারবার কেন ফোন করছে?
দেখো ওনাদের বই আছে এটা নিন
I make a paper the petition. Next.
Item number 9.
Item number 9.
I am appearing for issue number 6 and 7. My lord, on the earlier occasion, my lord, we
I am
submitted.
the petition. Let me start. Let me start.
yes
Huge unauthorized construction, my lord. 5 additional floors without any sanction plan. And G+1, where there was deviation more than 100%. The lordship lord intervened. Report was filed by the corporation. Then, my lord, after many my lord matters, contempt and everything, my lord, after that, my lord, 5 the illegal floors have been demolished. So far as G+1, my lord, the side deviation of more than 100% was not demolished. Corporation appeared and undertook before your lordship on 21st of May to 24th that they will take further steps and file a report before your lordship. Then, my lord, that order was carried in appeal before the division bench. The appeal was kept pending for a long time, my lord. They sought for time on several dates. Ultimately, appeal has been disposed of, saying that the matter is pending before the single judge, nothing to interfere. So today, my lord, as per the undertaking, corporation has to, my lord, file the report and, my lord, demolish the rest of the illegalities.
Now, my lord, before my lord, that my lord, we are submitted, my lord.
Regarding 4 floors, we have completely demolished. That we have completely demolished. Regarding G+1, we have found that there are deviations, and for that reason, I had to file a report. But as the demolition date has been fixed on 27th January 2025 onwards, for that reason, I could not file the report. After the demolition, we will file the report. That
It
is,
is-
I'm saying. That is this, due to Gangasagar Mela, the police cannot give us the support of police
assistance
assistance.
when is to end
We have already
no when is
talked to the police. That's 27th.
on 27th we will undertake to demolish
27th, we are going to demolish.
okay
My lord,
It is
before
informed
that,
by
my lord,
the
there is also,
advocate.
my lord, an application is also there, my lord.
it is
My lord,
informed
kindly
by
hear me, my lord, before passing order, my lord.
it is informed by learned advocate for the Howrah Municipal Corporation that 27 January 2025 has been fixed for taking steps in respect of demolition of the G+1 structure. Yes,
My lord, we earlier occasion, my lord, we have submitted, we have filed an appeal against that order by which your lordship directed to demolish, my lord. That is the remaining portion. My lord, we have filed the appeal. Order date, my lord, 21st May 2023. They have also filed an appeal. Then, my lord, that appeal was heard on 29/11/2024. The submission that has been made by my learned friend is not correct. Kindly see, my lord, the order. My lord, we have filed an application. First, my lord, that is also appeal. My lord, kindly see, my lord. Page
Can
93,
one to the-
addition R5.
Can one-
That application is there, my lord. Want to see?
ওয়ানটা আসেনি দেখো চেক করো your copy of the order of the application নাও ওটা নাও মিস্টার ব্যানার্জি কাছে
Two appeals are taken up for another hearing on both are directed against an impeding order passed in a pending repetition. As noted above, the impeding order dated May 21st, 2024, passed in WP number this petition did not decide any of the rights of the parties to the litigation finally. In such circumstances, we are not minded to interfere in this present appeal. Mad number so and so, along with all connected applications, is both the appeals are disposed of without any order as before. Then my last portion. All points raised by the parties are kept open to be decided by the learned single judge. So my lord, we raised some points in the appeal that were to be decided by your lordship. My lord. That's why, my lord, we have filed this application. Kindly fix up a date for hearing the issues. That
Have it served with a copy?
They have served, it can be hard today itself, if the copy is there. They
দাও
seek for regularization. It may be taken up.
আসেনি মানডে তো রেখে দাও It is informed by the court officer that the application being can 1 of 2025 had not been received by the court. Department is directed to place can 1 of 2025 positively on the next date. Place this matter on কবে আসবে Monday or Tuesday তে You intend to file any opposition to the application?
Question of law, points raised, so kindly decide on that.
Okay. তাহলে ওই দিনে রেখে দিন 14th
14.
Item number 10.
APF for the respondent.
His pleadings are complete.
No, yes, affidavit.
Sir.
Yes.
Lord, the petitioners before your lordship, Lord, their predecessor in interest was allotted a lower income group plot. Lord, measuring, telling Lord, measuring 14 tax, less than Lord 1 kata by the KMDA. Lord, after payment of the consideration amount and others, he made a construction on the said land. Lord, your lordship will get the deed at page 14. This is the deed, this deed. 9th April 2003.
Yes. Yes.
Lord, thereafter, Lord, your lordship kindly come to page 20. The allot him, Lord, the executed the will. By that will, Lord, he bequeathed the said property in favor of the petitioners. Page 20, Lord, your lordship will get it.
at page 20. Yes, Lord, that's the Dilip Kumar son, Lord, the allotee, he died on 26th August 2005. August? Lord, 26th August 2005. Yes. Lord, thereafter, the petitioners, Lord, applied for probate. Before this honorable court, in its testamentary and intested jurisdiction, and Lord, ultimately probate was granted. Lord, your lordship kindly come to page 22. Yes. Second April. On 2nd April. Yes. 2009. 2nd April 2009. 9. Lord, after this probate was granted, Lord, these petitioners, Lord, they applied before the Kolkata Metropolitan Development Authority for getting their name mutated instead of Dilip son. There is only one petitioner. Two. Lord, upon presentation of the application filed by the petitioners, Lord, the KMDA authority demanded an amount of rupees 6,24,394 for the purpose of mutation. Lord, your lordship will get the backups which has been narrated in our application representation before to the chief executive officer at page 46. Service charge 5,29,148. Add CGST 9%, add CGST 9%, total 6,24,394. What is the date of this demand? Lord, on? Yes.
July.
29 July.
29 July 2019, Lord. Kindly see page 54. Got it. Lord, this demand is the subject matter of this writ petition.
The date গুলো দাও ফেব্রুয়ারি মাসে জ্যাম করবেন বড় বড় ইয়ারিং পড়ে যাবে ফিফথে আছে সিক্সথে আছে সেভেন্থ এইথ এরকম দেখে ছড়িয়ে রাখবে Mr. So and so, learned advocate for the petitioner. Due to paucity of time, the hearing could not be concluded. Place this matter on 10th, 12th February. এটাকে একটা ফাইলে রাখবে Down.
Original side daily list item number 1.
ঠিক আছে? B. Matter is appearing under the heading to be mentioned. Inadvertent typographical error has crept into the cost title of the order dated 21st August 2024, mentioning the name of the deceased as Vijay B. Bombay B. Bijay Kumar Poddar Poddar instead of Vijay V. বাকিটা সেম শুধু বিজয় আর বিজয় the name of the deceased should be read in order dated 21st August 2024 as Vijay Vijay instead of Vijay Kumar Poddar. The aforesaid order is modified to the above extent. The other portions of the order shall remain unaltered.
Item number 2.
Item number 2 and 3, I do appear for the applicant. Now, your lordship will kindly consider the last order. Your lordship ordered for a report. That report is before my lord. My lord will consider that report, my lord. It's regarding a sale of a property in a suit for partition.
Valuation report দিয়েছে
As for the Kolkata Municipal Corporation.
ভ্যালুয়ার এটা একটু খুলুন অঞ্জন বাবু এই রিপোর্টে ভ্যালুয়েশন রিপোর্ট
Question.
Three 172 741. Where is Mr. Das? Where is Mr. Das?
Make his mark.
By which order this direction was given for causing publication?
I will just indicate, my lord. So order dated 2nd December 2020.
Publication for sale?
Publication for sale. I will
It was
just
5th August, no? 5th August.
2nd December, my lord ordered for the valuation.
Peruse the report of learned registrar original site dated 7th January 2025. The learned registrar original site has annexed the valuation report as directed, PD order dated 2nd December 2024. Para, it is found from the evaluation report that the property in question is valued at rupees 5172,741. What will be the earnest money of this? 10% of this?
With 10%. A bona fide purchaser should deposit a 10%.
The learned special officer is directed to cause publication for sale of the property in question, mentioning the in terms of order dated 5th August 2024, mentioning the reserve price as rupees 51 agaji amount of gold. And earnest money of rupees 5 lakhs.
10%. 10% of the
10% of the reserve price.
10% of the purchase money, which consideration, which the offer price, my lord.
So then that will vary.
Say 5 lakhs, my lord. That is
5 lakhs.
fixed.
Learned special officer shall file a report on the returnable date. List this matter after. Is it the February they go? Is this matter on 4 weeks? No, 4 weeks.
My lord, a copy of this report be provided to us.
Which report?
This report, valuation report, my lord.
It's not required.
If applied for, we will apply and they will give us a copy. We'll see what is the.
I have mentioned the valuation. No? You can inspect that. What is the necessity of going through? It is a registered valuer has given a valuation.
51 lakhs.
51,72,000.
Yes.
Number 4.
Lord, may it please your lordship.
Butcher. No, Butcher. It will take time. Mr. Chatterjee, it will take.
I think so, Willard. Because there is a request for rising at 3:30.
I think.
Where is Mr. Medora?
His learned junior is here.
Okay.
I will also join after some time.
May I start from the
You were referring to the written statement.
Yes, Lord, I had concluded placing the written statement, and the intention was to demonstrate before your lordship the issues involved in the suit and the fact that the deceased plaintiff, that is Mr. Tellis, was not litigating for a money relief simpliciter. He was asserting a right which is very much disputed for the purpose of arriving at the stage of the money relief. He is rather in the suit disputing the validity of an amendment of the pension fund trust deed carried out in 1970. He is praying for a declaration that the amended trust deed of 1970 is invalid. He is asking for a mandatory injunction for restoration of certain monies which he alleges to have been appropriated from the corpus and to his detriment. It is only if he succeeds in these aspects, then he becomes entitled to the money relief which he has claimed in prayer K or some prayer down the line. So therefore, this is not a case in which the plaintiff has an established and crystallized existing right to a certain amount of pension, and he is suing for that right. That is a situation in which the heirs will automatically step into his shoes, because if that relief is granted, it will enrich his estate, which will ultimately be inherited by the heirs. But here, his entitlement to that sum is itself preconditioned upon his succeeding in various other challenges which he has advanced in the plaint, and including a challenge based on a breach of trust. He alleges there is a beneficiary and trustee relationship between the trustees and himself. That, in my humble submission, is a right to sue, which obviously belonged to the deceased plaintiff, but which cannot, Millard, survive to his heirs in terms of Section 306 of the Indian Succession Act, which says that something which cannot be enjoyed by his heirs cannot, Millard, survive. Millard, in continuation of this submission, and for that purpose, I had placed the plaint.
CPC to Yes.
That purpose, I had placed the plaint in detail, as also, Millard, the written statement. And I had shown that the plaintiff, it is not that the plaintiff is not enjoying a pension. He is enjoying the admitted pension. He is also enjoying an additional deferred pension, which has its genesis in the very 1970 amendment which he impugns, because to compensate for the contributions which the plaintiff had earlier made up to 31st of December 1969 to the pension fund, this concept of additional deferred pension was devised. And the plaintiff was in service long after the additional deferred pension came into existence. He did not protest at that time, and even after retirement, he has been receiving the pension and the additional deferred pension. And what he now says is something over and above that, for which he has to succeed in establishing that the entire amendment of 1970, which is, of course, impact a huge body of employees, is void. And then only, and there has been a breach of trust, and there has been a misappropriation of trust funds, and then only he can claim what he is claiming in terms of money. And now, Millard, to save your lordship's time and Millard, to capture my submissions in one page, Millard, may I hand up a short submission on only the aspect of whether right to sue survives. And may I, Millard, it is only 5 paragraphs. May I place it? Then I'll come to the Millard decisions.
Yes.
Millard, first paragraph, which I have already submitted orally, the question of survival of right to sue
both in case of a testamentary and intestate succession, is governed by Section 306 of the Indian Succession Act 1925. The instant suit is not premised on any accrued or vested or existing or crystallized right of the deceased plaintiff to a higher pension on the date of institution of the suit or at the time of death of the deceased plaintiff. The suit is for a declaration of an invalidity of an amendment of a pension fund trust deed, which has been approved by income tax authorities, and for restoration of all monies allegedly appropriated from the original trust fund consequent on the aforesaid declaration of invalidity. The original plaintiff was admittedly getting pension on the basis of the trust deed operative at the time of filing of the suit and till his death, including additional pension, which is in fact an additional deferred pension, which is a product of the impugned amendment. Hence, the money relief prayed for, which according to the applicant survived to the heirs of the deceased plaintiff, and which necessarily has to be a case of intestate succession, or in any event a case of partial intestacy, not having been referred to at all in the will allegedly left by the deceased plaintiff, is conditional upon the plaintiff, this is very important, is conditional upon the plaintiff succeeding in obtaining a declaration of invalidity of the trust deed or a mandatory injunction as prayed for. As submitted above, the money relief is thus not based on any existing or accrued right of the deceased plaintiff at the time of institution of the suit or at the time of his death. Hence, there is no question of an automatic accretion to the estate of the deceased, which is capable of enjoyment by the heirs of the deceased plaintiff, which, my lord, is a requirement of Section 306. The right to sue for declaration of invalidity of the pension fund trust and for other reliefs preceding the relief of money decree is personal to the plaintiff, particularly when it relates to an additional disputed pension. The claim to the additional pension is itself disputed. Such action cannot be pursued by the heirs. Those are not and cannot be subject matter of enjoyment by the heirs in terms of Section 306 of the Indian Succession Act 1925. And if such action cannot be pursued by the heirs, the stage of money relief would not be reached. Then, my lord, paragraph 5 is the last paragraph. The decision cited on behalf of the applicants concerned situations where there was a challenge to curtailment of indisputable existing rights by actions independent of such right. And in case the challenge to such independent actions succeeded, the money relief or accretion to the estate of the deceased would automatically follow. The said decisions are thus distinguishable on facts and are of no relevance in the present case. This, in brief, my lord, is the structure of my submission. Now, my lord, on the question that it is particularly so that the right is personal to the plaintiff is more pronounced in the context of pension. On that, my lord, may I, my lord, cite a judgment of the Supreme Court reported in 1983, Volume 1, Supreme Court Cases 305. I'll give you a lordship of paragraph. Kindly give me a moment. No, I'm like 8. Yes. Kindly come, my lord, to paragraph 20 of the judgment. My lord, before I place, my lord, may I tell your lordship in a nutshell what the facts were. Well, the facts were very short. There was a certain formula for payment of pension to central government employees, which was revised for the benefit of the employees. There was a revision to the benefit of the employees. But while doing so, the central government said that this revised pension, increased pension, will be applicable only for employees who retired on and from a given date, not the employees who have retired before. So the employees, some of them, challenged this circular by which this stipulation or this cutoff date was introduced, saying that it is discriminatory because pensioners constitute a homogeneous class and therefore there cannot be a subclassification within that homogeneous class. And some persons cannot be left out on the ground of a cutoff date. In that context, the Supreme Court in a constitution bench examined the concept of pension. I am on the concept of pension and how and the object for which pension is granted to an employee. Kindly come, Miller, to paragraph 20. The antiquated, at page 320, the antiquated notion of pension being a bounty, a gratuitous payment depending upon the sweet will or grace of the employer, not claimable as a right, and therefore no right to pension can be enforced through court, has been swept under the carpet by the decision of the Constitution Bench in Devkinandan Prasad versus State of Bihar, wherein this court authoritatively ruled that pension is a right and the payment of it does not depend upon the discretion of the government but is governed by the rules, and the government servant coming within those rules is entitled to claim pension. It was further held that the grant of pension does not depend upon anyone's discretion. It is only for the purpose of quantifying the amount having regard to service and other allied matters that it may be necessary for the authority to pass an order to that effect, but the right to receive pension flows to the officer not because of any such order, but by virtue of the rules. This view was affirmed. There are various kinds of pensions, and there are equally various methods of funding pension programs. The present inquiry is limited to non-contributory superannuation or retirement pension paid by government to its erstwhile employee and the purpose and object underlying it. Initially, this class of pension appears to have been introduced as a reward for loyal service. Probably the alien rulers who recruited employees in lower echelons of service from the colony and exported higher level employees from the seat of empire wanted to ensure, in the case of former, continued loyalty till death to the alien rulers, and in the case of latter, an assured decent living standard in old age, ensuring economic security at the cost of the colony. In the course of transformation of society from feudal to welfare, and as socialistic thinking acquired respectability, state obligation to provide security in old age and escape from undeserved want was recognized, and as a first step, pension was treated not only as a reward for past service, but with a view to helping the employee to avoid destitution in old age. The quid pro quo was that when the employee was physically and mentally alert, he rendered unto master the best, expecting him to look after him in the fall of life. A retirement system therefore exists solely for the purpose of providing benefits. In most of the plans of retirement benefits, everyone who qualifies for normal retirement receives the same amount. And Blakeney is quoted. As the present case is concerned with superannuation pension, a brief history of its initial introduction in early stages and continued existence till today may be illuminating. Superannuation is the most descriptive word of all, but has become obsolescent because it seems ponderous. Its genesis can be traced to the first Act of Parliament in UK to be concerned with the provision of pensions generally in the public offices. It was passed in 1810. The Act, which substantially devoted itself exclusively to the problem of superannuation pension, was Superannuation Act of 1834. These are landmarks in pension history because they attempted for the first time to establish a comprehensive and uniform scheme for all whom we may now call civil servants. even before the 19th century, the problem of providing for public servants who are unable through old age or incapacity to continue working has been recognized. But methods of dealing with the problem varied from society to society and even occasionally from department to department. A political society which has a goal of setting up of a welfare state would introduce and has in fact introduced as a welfare measure wherein the retiral benefit is grounded on considerations of state obligation to its citizens who have rendered service during the youthful span of life must not be left to penury in their old age. But the evolving concept of social security is a later day development. And this journey was over a rough terrain. To note only one stage, in 1856, a royal commission was set up to consider whether any changes were necessary in the system established by the 1834 Act. The report of the commission is known as Northcote Trevelyan Report. The report was pungent in its criticism when it says that in civil services comparable to lightness of work and the certainty of provision in case of retirement owing to bodily incapacity, furnished strong inducements to the parents and friends of sickly youths to endeavor to obtain for them employment in the service of the government, and the extent to which the public are consequently burdened, first with the salaries of officers who are obliged to absent themselves from their duties on account of ill health, and afterwards with their pensions when they retire on the same plea, would hardly be credited by those who have not had opportunities of observing the operation of the system. This approach is utterly unfair. This is what the Supreme Court says. In modern times, public services are manned by those who enter at a comparatively very young age with selection through national competitive examination, and ordinarily the best talent gets the opportunity. Let us therefore examine what are the goals that pension scheme seeks to serve. Let's observe. A pension scheme consistent with available resources must provide that the pensioner would be able to live free from want, with decency, independence, and self-respect, and two, at a standard equivalent at the pre-retirement level. This approach may merit the criticism that if a developing country like India cannot provide an employee while rendering service a living wage, how can one be assured of it in retirement? This can be aptly illustrated by a small illustration. A man with a broken arm asked his doctor whether he will be able to play the piano after the cast is removed. When assured that he will, the patient replied, "That is funny. I could not before." It appears that determining the minimum amount required for living decently is difficult. Selecting the percentage representing the proper ratio between earnings and the retirement income is harder. But it is imperative to note that as self-sufficiency declines, the need for his attendance or institutional care grows. Many are literally surviving now than in the past. We owe it to them and ourselves that they live, not merely exist. The philosophy prevailing in a given society at various stages of its development profoundly influences its social objectives. These objectives are in turn a determinant of a social policy. The law is one of the chief instruments whereby the social policies are implemented, and pension is paid according to rules which can be said to provide social security, by which it is meant those legal mechanisms primarily concerned to ensure the provision for the individual of a cash income adequate when taken along with the benefits in kind provided by other social services, such as free medical aid, to ensure for him a culturally acceptable minimum standard of living when the normal means of doing so fail. Viewed in the light of the present day notions, pension is a term applied to periodic money payments to a person who retires at a certain age, considered age of disability. Payments usually continue for the rest of the natural life of the recipient. The reasons underlying the grant of pension vary from country to country and from scheme to scheme, but broadly stated they are as compensation to former members of the armed forces or their dependents for old age, disability, or death, usually from service causes, as old age retirement or disability benefits for civilian employees, and as social security payments for the aged, disabled, or deceased citizens made in accordance with the rules governing social service programs of the country. Pensions under the first head are of great antiquity. under the second head, they have been enforced in one form or another in some countries for over a century. But those coming under the third head are relatively of recent origin, though they are of greatest magnitude. That is mere old age. There are other views about pensions, such as charity, paternalism, deferred pay, rewards for service rendered, or as a means of promoting general welfare. But these views have become more sure. Pensions to civil employees of the government and the defense personnel as administered in India appear to be a compensation for service rendered in the past. However, as held in Dow versus Board of Education, the pension is closely akin to wages in that it consists of payment provided by an employer, is paid in consideration of past service and serves the purpose of helping the recipient meet the expenses of living. This appears to be the nearest to our approach to pension, with the added qualification that it should ordinarily ensure freedom from undeserved want. Now, Millard, I will not trouble your lordship any further with this judgment. Millard, my submission is based on this, that pension is a concept which is inextricably linked with a person who has rendered service, and the objective is to ensure for him financial assistance and a decent living in his sunset years. Therefore, Millard, this is an area, this is an aspect which is very unique to the person who has rendered the service, and normally would not, the right to sue for it would not survive. But we have a better case, because here even the plaintiff is enjoying a pension. What he wants is an additional pension, which is very much disputed on the basis of certain declarations, certain challenges to existing situations, and thereafter, if he succeeds in those, come to the stage of a money relief. So first of all, Millard, pension is unique to the employee, and secondly, here is a case in which there is no crystallized or existing or predetermined right to any amount of pension. Whatever is predetermined, the plaintiff was getting, that is undisputed. Now, Millard, one more judgment of a high court on this, and Millard, before I cite the high court judgment, Millard, the plaintiff is very, I would say, is conscious of this position, because he has not referred to this pension dispute or his proceeding, this proceeding in the Calcutta High Court, in the will which his heirs have annexed to the affidavit in reply. Although the plaintiff has taken, the deceased plaintiff has taken pains to refer to family pension payable to his wife.
Reply
That,
to
Millard, I'll give you a lordship, Millard, the affidavit, kindly, if your lordship has the affidavit in reply. It is an affidavit affirmed by Soraya Mary Rodriguez on 14th of May 2024. Kindly, Millard, come to page 13 of the affidavit, annexure B. This, Millard, is said to be the last will and testament of the deceased plaintiff, executed in the year 2011, when this suit was already instituted and was pending. Now, the plaintiff, apart from his other assets, takes pains to refer to the pension he is receiving and how he wants it to be dealt with at page 18, para capital C, or clause capital C, if I may say so. In respect of the pension which I am receiving from ICI India, doesn't talk about any further entitlement or that he is entitled to more. After my demise, my wife Hilda shall be solely entitled to the widow pension from ICI India in entirety for the remainder of her lifetime. Milord, it is a different thing that his wife predeceased him on 9th of June 2020, whereas he expired on 17th of October 2023. But then the intention is clear that he knows that this is an aspect which will not survive to his heirs, and therefore he takes pains not to refer to it in the will. This is, Milord, of course, a collateral submission, but it reinforces my submission that the pension, the right to sue for the disputed pension does not survive to the heirs. Now, Milord, on the question of only an existing right surviving to the heirs and not any disputed right, kindly, Milord, take a judgment, a division bench judgment of the Patna High Court reported in 1968, SCC Online, Patna 11. Well, briefly stated, here what happened was that there was an application for grant of a permit under the Motor Vehicles Act by one Ram Bichar Singh. While the application for the grant of permit was pending, Ram Bichar Singh expired, and his wife Dhani Devi applied for substitution for stepping into the shoes of her deceased husband for the purpose of obtaining the permit. It was initially allowed, and thereafter, Milord, it was challenged. The challenge ultimately reached the High Court. Milord, while considering this, the High Court ultimately held that because a right, an application for a permit does not constitute an existing predetermined right, it cannot devolve upon his wife and quash the orders passed by the authorities. Kindly, Milord, take, and the division bench considered section 306 of the Indian Succession Act. Kindly, Milord, take paragraph 2. Thereafter, Ram Bichar Singh, who had applied for the license, died on April 22, 1905, leaving behind several heirs, including Dhani Devi. Deceased Ram Bichar Singh also held several permits for other routes. That is different, because if he is already holding a permit, that is transferable and heritable. Under section 61(2) of the Act, the Transport Authority transferred the permits held by Ram Bichar Singh to respondent Dhani Devi. After observing necessary formalities, the matter for grant of permit for the route came for consideration before the Bihar Regional Transport Authority on May 4, 1986. No application for substitution of the name of respondent Dhani Devi in place of her husband Ram Bichar Singh was filed before the authority, nor did the authority substitute her name in place of her husband. Further, the Regional Transport Authority, by its order dated May 4, 1966, decided to grant permit for the route to respondent Dhani Devi. The petitioners, along with two other persons, filed an appeal before the appeal board, which by its order dated 20th August 1966 set aside the order of the Regional Transport Authority granting permit to respondent Dhani Devi and granted permit of the route to Sant Bihari Sharma on certain terms and conditions, failing which to Chandrakirti Singh on the same terms and conditions. Sorry. Being aggrieved by the aforesaid order of the appeal board, respondent Dhani Devi, petitioner Chandrakirti Singh and one Rajeshwari Prasad Singh filed applications before the state government under section 64A of the Motor Vehicles Act. The three applications were heard together. The application of respondent Dhani Devi succeeded, and the order of the appeal board granting permit to petitioner Sant Bihari Sharma was set aside, and the order of the Transport Authority granting permit to respondent Dhani Devi was restored. The applications of petitioner Chandrakirti Singh and Rajeshwari Prasad Singh were dismissed. Hence, the petitioners in the two cases have filed the applications for quashing the order of the Transport Minister granting permit to respondent Dhani Devi. Petitioner Chandrakirti Singh has also challenged the order of the appeal court granting permit to Sar Bihari Sharma. Learned counsel for the petitioners urged before us that the impugned order contains several errors of record. It was pointed out that no application for substitution of the name of respondent Dhani Devi in the application for permit by her husband was filed before the Transport Authority, and her name was not substituted. This allegation is not denied by respondent Dhani Devi in her counter affidavit. Hence, the minister committed an error of record in holding that respondent Dhani Devi, wife of Ram Bichar Singh, applied to the Transport Authority for substituting her name in place of her husband, deceased Ram Bichar Singh, and the Transport Authority accordingly substituted her name. Learned counsel is not right in his submission. What is stated in the order is that Ram Bichar Singh held some other permits within the jurisdiction of the Regional Transport Authority and he died. And the respondent Dhani Devi, wife of the deceased Ram Bichar Singh, being the legal successor to all rights and interests of the deceased, applied to the Regional Transport Authority for substituting her name in place of her deceased husband, Ram Bichar Singh, and accordingly it substituted her name. This position is almost accepted by all the parties concerned. Therefore, the uncontroverted fact is that no application by respondent Dhani Devi was filed for substitution of her name, nor did the Regional Transport Authority substitute her in place of her husband. In the impugned order, it is not stated that any such application for substitution was made. A counter affidavit was filed on the 10th of January on behalf of Chandrakirti Singh along with a letter from the North Bengal Bihar Regional Transport Authority dated such and such, stating that no application for substitution of the name of Dhani Devi in place of her husband was filed by her. In such circumstances, learned counsel for the petitioners in both the cases contended that the right to apply for the grant of permit was a personal right which ended with the death of the applicant, and as such, respondent Dhani Devi had no right to claim the grant of permit simply because her husband had filed an application. Learned counsel for respondent Dhani Devi asserts she had a right to be substituted for the grant of permit in place of her husband, who had already made an application for the same. The main question for consideration is whether Ram Bichar Singh applicant has acquired some right which could be transmitted to her widow respondent Dhani Devi after his death. The scheme of the Motor Vehicles Act does not support the accrual of such a right in the heir of the applicant. Section 57 of the Act and Rule 46 made under the Act provide complete procedure for making an application and its consideration for the grant of a stage carriage permit. No provision for substitution is made in case the applicant dies before the grant of permit. After the applications are filed, they are published in the official gazette and the representations and objections are invited within certain time. Thereafter, the applications for objections are heard and finally decided, and then permit is granted to a suitable person. Long before the final hearing of the applications on May 4, 1966, Ram Bichar Singh died, and if the respondent Dhani Devi be treated as an applicant in place of her husband, there was no occasion for making any representations or objections against her application and their consideration at the time of hearing before the Regional Transport Authority. It was contended on behalf of respondent Dhani Devi that since her husband was dead and his other permits had been transferred to her, she should be considered for that permit in view of the fact that the applicant was an experienced and displaced operator having lost 40 miles, etc. The Regional Transport Authority, without examining the fact whether she was an experienced operator or not, granted permit to her on the fulfillment of certain conditions. The Regional Transport Authority perhaps thought that the widow of Ram Bichar Singh was entitled to get the permit as a matter of right in place of her husband, because in Annexure A, the name of the applicant was mentioned as Sri Ram Bichar Singh, and his past history of the previous 4 years was also mentioned as a displaced operator, Chapra, Sewan, etc. of the route, and held 3 permits which were transferred in the name of his wife after his death. The displaced operator was Ram Bichar Singh. He might be an experienced operator, but there was nothing before the Regional Transport Authority to assume that because Ram Bichar Singh was an experienced operator, the widow of Ram Bichar Singh should be so held and permit should be granted to her, admittedly, etc. Now, Millard, kindly come to paragraph 8, because that the other portions deal with the Motor Vehicles Act with which we are not concerned. Paragraph 8 says, respondent Dhani Devi, would have also filed an application for the grant of permit in respect of the route in question in her own right, as Ram Bichar Singh did. Her application could have also been considered along with other applications. The right to apply is the personal right which the applicant was entitled to exercise. It does not create any right in the subject matter of the application in favor of the applicant, which means, well, at Ram Bichar Singh, at the stage of making the application, there was no right created in him, which could devolve. The applicant can only expect that his application at best could be considered favorably, as there was no certainty that the consideration would result in his favor. Hence, after the death of applicant Ram Bichar Singh, no right could be left to be claimed by respondent Dhami Devi as an heir of Ram Bichar Singh. Learned counsel for the petitioners drew our attention to a decision of the Privy Council in Director of Public Works versus Sang, 1961, Appeal Cases 901. In that case, before the grant of a rebuilding certificate by the Governor in Council could materialize after hearing the applicant and the objectors under interpretation ordinance, the ordinance itself was repealed. There was a provision in the repealing act which read as follows. The repeal of any enactment shall not affect the previous operation of any enactment so repealed or anything duly done or suffered under any enactment so repealed, or affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed, affect any investigation, legal proceeding, or remedy in respect of any such right. Therefore, the question arose whether the applicant had acquired some legal right to enforce even after the repeal. The Privy Council observed as follows. At the time of the repeal, all the procedure under sections 3A and 3B have been followed, and it can properly be said that the stage had been reached when the lessee could expect and was entitled to have the petitions and cross petition considered in due course by the Governor in Council and to have a decision reached. Would such expectation or entitlement, well, I would submit that the claim of Mr. Telefix in the suit was at the stage of an expectation or entitlement in the context of his prayers for declaration of invalidity. Be regarded as a right or a privilege, either acquired or accrued within the meaning and intendment of the interpretation ordinance? Or was such expectation or entitlement something that necessarily came to an end at the time of the repeal? Was the lessee therefore possessed on April 9 of a right or privilege within the meaning of the interpretation ordinance? In their lordship's view, the entitlement of the lessee in the period prior to April 9 to have the petitions and cross petition considered was not such a right. On April 9, the lessee was quite unable to know whether or not he was given a rebuilding certificate. And until the petitions and cross petition were taken into consideration by the Governor in Council, no one could know the question was open and unresolved. The issue rested in the future. The lessee had no more than a hope or expectation that he would be given a rebuilding certificate, even though he may have had grounds of optimism as to his prospects. The above observation applies to the facts of the present case. Before Ram Bichar Singh's application could be disposed of, he had no right to the route in question. Therefore, his widow Dhani Devi would not claim a right in the route to be considered in place of her husband by virtue of being his heir on the basis of his application, which ended with the death of Ram Bichar Singh. Now, Milord, then an Allahabad High Judgment is referred to in support, and contrary view of Mysore High Court is referred to. Then kindly come to para 16. Section 306 of the Indian Succession Act lays down as follows. I will not read it out because I have already placed that section before my lord yesterday. Para 17. This section always contemplates, this is very important, this section always contemplates a case of pre-existing rights for which action was brought by the deceased. The right to continue the action vested in the executors or administrators, as the case may be, and not in the heirs of the deceased. I have already held above that the applicant had no pre-existing right in the matter of the grant of the permit before the permit is granted. Therefore, the principles of this section would not be stretched to a case of this kind, and the heir could not be allowed to continue such application. I regret I am unable to subscribe to the view taken by the Mysore High Court in this case. For the reasons stated above, I would rather prefer to follow the view held by the Allahabad High Court in AIR 1957, Allahabad 471, and hold that the respondent Dhani Devi had no right to be considered for the grant of permit after the death of her husband, when she was not herself an applicant in her own right. The order of the Regional Transport Authority and that of the minister granting permit to Dhani Devi are bad in law and must be quashed. Well, having said that, I shall now pass on to dealing with the authorities cited by my learned friend, Mr. Medora, on this question of survival of the right to sue. And I'll deal with them in the order in which they have been cited. The first decision which my learned friend had referred to is reported in AIR 1967 Supreme Court 1124. I
Yeah.
thought we have a copy of the judgments already,
Yes.
which were handed up.
No.
Yes. And my learned friend, I think, relied on paragraph 15.
Yes.
Yes. Finally, it was heard that since defendants Mode Narayan and Rajvallabh Narayan had died during the pendency of the proceedings, the High Court was incompetent to pass a decree for account against their estates. Rajvallabh, who was defendant 6, died during the pendency of the suit in the trial court. And Mode Narayan, who was defendant number 1 in the suit, died during the pendency of the appeal in the High Court. But a claim for rendition of account is not a personal claim. It is not extinguished because the party who claims an account, the party who is called upon to account, dies. The maxim actio personalis, moritur cum persona, a personal action dies with the person, has a limited application. It operates in a limited class of actions ex delicto, such as actions for damages for defamation, assault, or other personal injuries, not causing the death of the party. In fact, Millard, section 306 is being referred to here because these are the words of that section. And in other actions where after the death of the party, the relief granted could not be enjoyed or granting it would be nugatory. An action for account is not an action for damages ex delicto and does not fall within the enumerated classes. Nor is it such that the relief claim being personal could not be enjoyed after death or granting it would be nugatory. Death of the person liable to render an account for property received by him does not therefore affect the liability of his estate. It may be noticed that this question was not raised in the trial court and in the High Court. It was merely contended that because the plaintiff, Vijendra Narayan, was receiving income of the lands of his share, no decree for accounts could be made. The High Court rejected the contention that no account would be directed in favor of the plaintiff on that account. They pointed out that the mere fact that the plaintiff was in possession of some portion of properties of the joint family since 1941 cannot possibly absolve the defendants who were in charge of their dealings with the management of the properties from rendering accounts of the joint family estate. The plaintiff was since September 1941 severed from the joint family in estate and also in mess and residence, and he was entitled to claim an account from the defendants from September 1941, but not for past dealings. That the fact that the plaintiff is in possession of some of the properties will of course have to be taken into account. Now, we'll add two observations here as very important and makes the case totally distinguishable. First is that it says towards the middle of this paragraph, death of the person liable to render an account for property received by him does not affect the liability of his estate. So, Millard, in this case, the learned judges and the parties are talking about a present liability which is undisputed. The liability is not disputed. In principle, if somebody has received property, obviously the estate has incurred a liability. And secondly, it is reiterated again that the plaintiff, the last portion, the plaintiff was since September, sorry, well, it's before that. They pointed out that the mere fact that the plaintiff was in possession of some portion of properties of the joint family since 1941 cannot possibly absolve the defendants who were in charge of their dealings with the management of the properties from rendering accounts of the joint family estate. The plaintiff was since September 1941 severed from the joint family in estate and also in mess and residence, and he was entitled to claim an account from the dependents. Well, again, the entitlement to claim accounts is not disputed, which is not the case here. The entitlement of Mr. Tellis to a declaration of invalidity, to a mandatory injunction for Millard, his challenge to the validity of the trust deed is very much disputed. Therefore, the entitlement is not disputed in this case, but in this case, the entitlement is disputed. That, Millard, in my humble submission, makes in fact, all the cases distinguishable because all of them proceed on an existing crystallized right to obtain the reliefs. Now, Millard, the next decision, which my learned friend has referred to, reported in 1967, SCC Online, Gujarat 14. And the relevant paragraphs which he has relied upon are paragraphs 3, 13, 18, and 19. Will it kindly come to paragraph 3. The respondents to the petition is the state of Gujarat. On behalf of the respondent, the Deputy Secretary to the Government of Gujarat Home Department has filed an affidavit in rejoinder and contended that the petition had become infructuous due to the death of Ibrahim Bhai Chippa. The contention was that the petition did not survive as the reliefs claimed were personal to the deceased and the heirs and legal representatives, that is the present petitioner, had no right to continue the petition. On merits, the contention was that the order of reversion was not passed as a punishment, but on the ground that Ibrahim Bhai Chippa was unsuitable for the post of Deputy Superintendent of Police. The rest of the paragraph perhaps is not very important. Kindly come to 13. At page 207. The next question is whether the right to sue survives in the present case to the heirs and legal representatives of the original petitioner. The expression right to sue means the right to obtain the reliefs which the deceased has prayed for. And that is how the expression was construed in the case of Gopal Ganesh Abhayankar versus Ramchandra Sadasi, 1902 ILR 26 box. In the present case, the reliefs which are prayed for are to quash the order of reversion dated April 10, 1962, passed by the state, and for a declaration that the petitioner continued in the service as an officiating deputy superintendent of police, the present petitioners, that is the heirs and legal representatives of the deceased Ibrahim Bhai Tippa, can ask for relief for quashing the order of reversion dated 10th April 1962, as they are the persons interested in the estate of the deceased. Then, my lord, it is very important. If the order of reversion is null and void and therefore of no legal effect, the deceased was entitled to his salary as deputy superintendent of police. After his death, his heirs, the present petitioners, would be entitled to recover the amount of their salary. In respect of the second relief, Mr. Daru considered that present petitioners cannot claim the same. Mr. Chaya contended that the existence of the right is the foundation of the exercise of jurisdiction of the High Court under Article 226 of the Constitution, and that the legal right that can be enforced under Article 226 must ordinarily be the rights of the petitioner himself. And for this, Mr. Chaya relied upon the Supreme Court case of Calcutta Gas versus State of West Bengal. The contention of Mr. Chaya was that the right to obtain the relief of a declaration that the order dated 10th April 1962 was invalid and ineffective, and a writ for quashing the said order was the personal rights of the deceased Ibrahim Bhai. The heirs, that is the present petitioners, had no personal right to obtain such a relief. Mr. Daru, on the other hand, contends that they have such a right and relies on the following passage from the Judicial Review of Administrative Action by S.A. D. Smith. Whereas nearly all the cases on prohibition have arisen out of proceedings originally instituted before courts stricto sensu, the locus standi required of an applicant for certiorari has often been the subject of consideration in cases arising in the general field of administrative law. But most of the decisions have failed to provide a full exposition of the relevant principles, and many of the dicta are ambiguous. Moreover, it has never been clearly settled how far the rules relating to prohibition are applicable to certiorari. Now, we'll pausing here for a moment. Your Lordship has seen from paragraph 13 what I have expressly mentioned in my note, that here was a case in which there was no dispute regarding the salary, regarding the entitlement of the original petitioner to the salary. The dispute was regarding the order of reversion. If the order of reversion goes, the salary becomes automatically payable. It is an accretion to the estate of the deceased and therefore can be enjoyed. This is, Millard, again the distinguishing feature, that in our case, the very entitlement to the increased pension is itself disputed and very severely disputed, and a number of issues concerning even a personal relationship, personal status of the plaintiff as beneficiary of a trust are involved. So, Millard, it is not a case where a reversion order goes and the salary automatically follows. Had it been perhaps a case in which the salary entitlement to the salary was itself in dispute, the heirs of the petitioner would not have stepped in. Yeah. 18 and 19, I think, proceeds on the facts of this case. I'll not trouble you about that. The ratio is really in paragraph 13. Then, Miller, the next decision he has relied on is reported in ILR 1986, Delhi 108. At 118. Paragraph 23. Thank you. Oh, 20 onwards, I see. My learned friend has relied 20 onwards, particularly 22 and 23. Yes. Paragraph 20 at page 117. Whilst this appeal was pending, Mr. Motwani died on 7th August 1973. His son, Dr. Shamlal, moved an application in November 1973 for being pleaded as his legal representative. He said in this application that Mr. Motwani had left a will bequeathing all his movable and immovable property and claims against the government and others to him, and therefore he was entitled to be impleaded as a sole legal representative in place of Mr. Motwani. He also gave the names and addresses of the 3 other sons and 2 daughters and prayed that they be joined as respondents. Now, Millard, first distinguishing feature is that this appears to be a case of a testamentary succession, because Dr. Shamlal, son of Mr. Motwani, claims, as recorded in the judgment, that Mr. Motwani had left a will bequeathing all his movable and immovable property and claims against the government and others to him. If that be the position, the question assumes a different dimension, because he has to come to the root of a probate, and if the probate is granted, he automatically becomes entitled to the property. It is not a case in which he has to really step into the truth for pursuing a litigation, because it is recorded that Mr. Motwani had left a will in favor of his son. That is, Millard, number 1. Then kindly come, Millard, to paragraph 22. In his petition, Mr. Motwani prayed for a number of reliefs. The main relief sought was a writ of certiorari to quash the order of demotion dated 29th of March 1961 and the notice dated 19th July 1963, by which he was compulsorily retired. As a consequential relief, he sought reinstatement and also a direction to the Union of India to treat him as on duty and pay him all his dues according to rules. In his application for being impleaded as a legal representative of Mr. Motwani, he would be entitled to the arrears of salary, etc., which the petitioner himself would have been entitled to had he been alive. Again, Millard, it's a question of entitlement to arrears of salary, which does not appear to be disputed. What is being disputed is the order of compulsory retirement, which, if it is found illegal, automatically leads to the conclusion that the arrears of salary goes to the deceased person and therefore devolves upon his heirs. Paragraph 23. It seems to be now well settled that although a person who has been demoted or whose service has been terminated can obviously no longer be restored or reinstated after his death if the impugned order is made, nevertheless, the pecuniary benefits which would have accrued to him in the event of restoration or reinstatement form part of his estate and can be recovered by his legal representative. Hence, the right to suit survives. Thus, in Ibrahim Bhai, Karim Bhai, and others versus State of Gujarat, which I think has already been referred to, that is the heirs of an officer who had been reverted were allowed to continue the proceedings, as they would be entitled to recover the amount of the salary to which he would have been entitled if the order of reversion was set aside. That case was followed in Narmahan Anand versus State of Punjab, in which the deceased officer had been dismissed and not merely reverted. It was also followed in Jang Bahadur by a single judge of this court in the case of a deceased officer who had been compulsorily retired. Another single judge of this court applied it to an officer who was removed from service. In Srimati Sajmo Devi and others versus Haryana State, the legal representatives were allowed to recover areas of pay, allowances, gratuity, pension, etc., after a suit for a declaration that the dismissal of the employee was wrongful had been decreed. Therefore, Millard, the common thread which runs through all these cases referred to here is that there is there is no dispute with these propositions, Miller. If the salary itself or whatever monetary is due is not disputed, is not preconditioned on some other factor on which the plaintiff has to succeed, automatically, Miller, once the cloud of a compulsory retirement or a reversion or a demotion or a dismissal goes, Miller, there is an automatic accretion to the estate which devolves, which is not the case here, and which makes this case again totally distinguishable on facts. Well, may I continue on the next occasion, because
Only just next occasion because if you apply the proposition of this decision, 1986, supposing we put it like this, that you started your argument that the plaintiff has to scale over prayer B and prayer C to have the entitlement of the monetary benefits. Now here is a case, it goes on like this, that if the appeal is allowed, then they will be entitled. So if you put it like this, that if a decree is passed, we are not deciding that whether it will be 70 will be void or 59 will be, amendments will be void. That is triable issues. But if the plaintiff succeeds in those prayers, then the entitlement of the legal years comes into operation.
yes,
So
true.
if that particular issue is not pursued by any of the parties and this application is rejected at the threshold, then the question of entitlement, which is in prayer D, cannot arise at any point of time.
Yes, because that is inevitable, because if the right to sue in respect of the first B or C or whatever that cannot survive to the deceased, then Millard, the deceased cannot come into the picture because it is a precondition. So therefore, Millard, the question which we are examining is whether the right to sue in respect of prayers B and C can survive, because if it cannot survive, then it will be futile for the heirs to pursue this action, because in any event, they cannot be heard on any question touching prayers B and C.
Okay.
Had the plaintiff been alive, the court, perhaps after considering B and C, would have held in his favor in respect of B and C and then come to the next prayer. But here, even if assuming, for argument's sake, that they are allowed to come into the suit, my submission would be, for testing the proposition, they cannot be heard at all on prayers B and C, which do not survive to them. And therefore, Millard, it would be futile for them to come into the suit, because even in that case, even by coming on record, their prayer, the monetary prayer cannot be reached at all. They cannot canvass B and C. That is the difficulty.
Okay, next. Or Mr. Abhijit Chatterjee, learned senior advocate, appearing on behalf of the respondents. He submits a short written notes of argument which is taken on record. A short written notes of argument which is taken on record. You have given a copy?
Yes, I've given a
copy, sir. February যেতে হবে দেখুন আর কবে যাচ্ছে due to paucity of time the hearing could not be concluded. List this matter on February মাসের ডেট 14th পারবো তার পরের সপ্তাহে আমি থাকবো না 14th এর আগে দিয়ে দিই না আমি ফিরে আসার পরে দেখুন 14th এর আগে কেন আবার রিপ্লাইর জন্য একটা দিন নেবে 14th ফেব্রুয়ারি কি ফাঁকা আছে 7th দেখে নিলেন যদি উইটনেস অ্যাকশনের পরে 14th করতে পারি 14th করুন 7th February.
7th February, I have some difficulty. Then it has to be, Millard.
Then on 14th. On 14th February. There is a witness action. Thereafter, I will take it up.
Very well. 14th February. I don't think it is possible before that. In January, it is not.
On.
Oh, then Millard, 14th February.
Thank you, sir. Okay.